Good morning and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are winding down our coverage of the Charles Jones trial out of Tampa. We're in penalty phase day 5. Good morning and welcome to Trial TV Live. Good morning and welcome to Trial TV. How many times can you hear me say good morning? All right, so winding down our coverage of Charles Jones trial. And we are in day 5 of the penalty phase. We're going to hear from the defense today. We heard from state yesterday. Defense has their turn. Then we will be in verdict watch. So settle in, get comfortable, and let's get started.
All I hear, go get the money, so I go get it. Hate means I do something right, so I'ma let him. Yeah, I'ma let him, yeah, I'ma let him. I hit the nail on the head, yeah, I'ma let him. All I hear, go get the money, so I go get it. Hate means I do something right, so I'ma let him. Yeah, I'ma let him, yeah, I'ma let him. I hit the nail on the head, yeah, I'ma let him. Early bird, go get the worm in the dirt. I could show you what I'm worth. My hands in the dirt. From where they look when you not. A hand in your purse. Hell if you think I'm last, hey, last should be first. Go ahead and go feast your eyes. Chefing up, cooking them pies. Leaving no slice, believe on a guy. Who in demand and who got supplies? You on the land, me I'm fly. Look at the miles, I be in skies. Right by my side, miss, look at them thighs. Up in Dubai, you see us. Black man, black sand beaches. Yeah. Backhand if you slick speaking. Yeah. Cut off if that hand reaches. Right. Sucker, I ain't about y'all leeches. All I hear, go get the money, so I go get it. Hate means I do something right, so I'ma let him. Yeah, I'ma let him, yeah, I'ma let him. I hit the nail on the head, yeah. All I hear, go get the money, so I go get it. Hate means I do something right, so
All right, good morning again. Welcome in, everybody. How's everybody doing? Hope you're doing well today. It is Friday, May 15th, 2026. We are in day 5 of penalty phase and anticipating a verdict watch today. We have 4 defense attorneys are going to give their closing arguments, and then we're going to have jury instructions, and then the jury will begin to deliberate. So I'm thinking probably by 2 or 3, I would say, they'll start to deliberate. So, all right, let's see who is with us today. The pretty chick. Good morning, Bama Green Eyes, JMS. Good to see you. Charles, welcome in. Green Eyed Cat, good vibes only. Hell Rider, good to see you guys. Sherry, good morning. Wizard of Ezzy, good to see you. Ronnie V. Florida, good morning to you. Texas Cat, good to see you. Hey, Linda, welcome in. Got manners. You got some chalky bickies and coffee. Nice. Jane Dixon, good morning, Pamela. Good to see you. Welcome in. Glee Roll, good morning. Good vibes only. Thank you for the floating hearts. That's fun to see. Christy, good morning to you. Molly, beautiful day in Michigan. Awesome. Good to see you. For Sue's EMT, good morning to you. JMS, it is Pizza Friday. Absolutely, Pizza Friday. It's Friday here and it's pizza. We're going to have some pizza today. Janice, good morning to you. Good to see you. Christy and Hellrider are dancing to the music. Awesome. Hey, Barry, good morning to you. Renee, good morning. Honey Badger, high alert. Good to see you guys. Thank you for joining us. All right. Iowa Backyard Cam sent Sparkles. Thank you for that. Excuse me. All right. Camilla, good morning to you. Kathy Davis. Good to see you. All right. I think I got everybody. Welcome in, people. All right. So let's see. All right. So today we're going to hear from the defense. Yesterday was all about the state. They had 2 witnesses on, 2 doctors to rebut what the defense brought in. Basically, they were talking about Davion and Isaiah's mental capacities, Davion with his brain scans, and then they had, Dr. Tanya Werner, forensic psychiatrist, and then Dr. Mark Glickstein. He was a diagnostic radiologist. He was refuting Dr. Mark Rubino, who was a neurologist. And of course, Werner was rebutting Dr. Einstein and Dr. Collins, both clinical psychologists, not psychiatrists, psychologists. So today it's going to be all about the defense. So we'll see how long the defense is going to go. Maybe I'd say at least an hour for each one. So you're looking at 4 hours. If they start at 9, they'll break for lunch. It's probably like 2 before they're done. Jury instructions will get us to about 3. Yeah, I could see them starting to deliberate between 3 and 4, and probably going until 6 or 7 even, and coming back with a verdict today. Sunshine, good morning to you. Good to see you. Colleen, good to see you. Thank you for joining us. Hope your horses are doing well. There's Sunshine. Ronnie, you're going to have leftover pan pizza. Awesome. Yeah, we're having, we have our order coming. We placed our order yesterday, and it's coming today. Wizard of Ezzy, is this even possible? I'm sort of pizza out. Might make something else. Yeah, we didn't have, it's been 2 weeks now since we've had pizza. It's like every 2 weeks or so we have pizza. But then it lasts like a week. So we have pizza. We have Pizza Friday pretty much every Friday. It's pizza. It's Friday. It's Pizza Friday. Why not? The Pretty Chick asks, after yesterday, how's everyone feeling about what the sentence will be? Well, after yesterday, pretty heinous what they did. It is pretty heinous what they did. But then I was kind of comparing it to the Texas, the FedEx driver guy, whatever, with the little girl. And people were saying, well, if this doesn't rise to the DP level, what does? And I would say that does. You know, what he did to that little girl, I would say, if anybody deserves it, they would be that guy. If you believe in those kind of things. A lot of people don't. And I get it. A lot of people can't, and that's nothing wrong with that either. We got a feed. All right, let me get this over here. We have a feed. Let's get us over here. So personally, I mean, this is my own personal opinion. Yeah, what they did was terrible. I mean, there's no question about it. I think we can all agree on that. Putting them to death, is that going to deter anybody? I mean, there's been like 100 years of research on deterrence, and it doesn't deter people. It really doesn't. So I personally would rather see them. I think I posted in chat yesterday. I'd rather see them get life without parole, and then instead of just rotting in jail, make them go back to these neighborhoods and make them say, hey, every day, go back into these neighborhoods and say, if you guys do that, then you will end up here, or even if they do get the death penalty, still have them go out instead of just sitting in their cells for 23 hours a day, have them go back into the communities and have them say, go and do these outreaches, go with these pastors and these folks that go out to these neighborhoods and have them talk to these kids, have them talk to the 10, 11, 12-year-olds and say, if you follow this life, you're going to be put to death. I mean, that's, I think, would be a constructive way of using the next 20 years that they have, or whatever it is. So that's just my personal opinion. I mean, even if they get DP, if they get sentenced, it is what it is. If they get life, it is what it is. I still would like to see them either way. I would like them to go back into the communities and say, look, guys, look, kids, when 9, 10, 11 years old, the whole scared straight. You guys remember that? I think they're still doing that. Do the whole scared straight thing and be like, if you guys go out and you follow this path, This is what's going to happen to you. Do you want that? And it may work, it may not. I don't know. But I would rather see them doing something to stop this, doing something to stop this cycle. And it's tough because when your cousin, brother, sister, mother, whatever it is, gets taken out by the ops, by the other side, what are you supposed to do? A lot of people are unable to, again, just look at the world. Just look at the world, look at the countries. Since the beginning of time, we've been, fighting with each other, and, how's it going to stop? How's it going to stop? So anyway, that's my 2 cents. So I don't, whatever happens. It's the jury's decision. It's not ultimately my decision. I'm only offering an opinion on what happens after that decision. I would like them, and whoever it is, let's just specifically with these guys, let's try to make, if you really want to make an example, if you truly want to make these guys, make them an example, get them back out into the community and get them talking. If Sean, if Sean truly has found religion, and Rashad has found religion, and he's leading these Bible studies and stuff like that, awesome. Go do that in the community. Go back to Jacksonville and go back into the communities and be like, little dudes, this is not the way to go. Or if you do this, it's an if-then statement. If you do this, then you're going to end up on the row. And if you want to do that, by all means, go for it. But think about all the people that you're going to be destroying. Think about all the families, all the friends, all that stuff. So anyway, that's what I think. Let's see. Ghazi says Sean's eyes looks like he's been crying. Wouldn't surprise me. Nicola, is today the last day? Possibly. It's the last day for evidence and closing arguments, and then they'll be deliberating. I think they'll be deliberating before the end of the day. So whether or not they finish today or they come back tomorrow, we don't know. Joanne Jedi Platypus, I don't know if my messages are going through. I'm getting an internal error message when I post, but good morning all. Yeah, I get that sometimes too. And just refresh. I get that sometimes. Like I'll type and it'll say error, and I just refresh my feed. But we can see you. Hey Margaret, how are you? The pretty chick says, I have been seeing a lot of social media posts of people using Sean as an example for the youth. That sweat equity comment really hit hard with a lot of folks. Good. I hope so. I hope this is digging down deep, Hellrider, I'm on the fence either way they go. I'm good with it. Renee, the aftermath of all this is because they're all in gangs and they have better choices in life. Kathy, you were getting those all day yesterday. Yeah, it happens. I just hit refresh. It's the only thing I can tell you. Barry, I think I know how this judge would sentence them. Oh man, an appellate review will have a lot of things to consider, especially after what we saw at the end of yesterday. Hey Ray, good day to you. How are you? Nicola says, I think life without parole is better than TP for these. Skrubnik, how are you? Carolina says, yesterday was powerful closing. Kathy, good morning to you. I wonder if the violence is still bad in Jacksonville. It is still 30 plus, active gangs. And, I haven't been seeing too much on that. I've been watching some of the news over there, and doesn't seem it's as bad, because a lot of these characters, the players, have been either taken out, are in jail. Queso's in jail. Hakeem Robinson, he's in jail. Ace is out of the city. So a lot of these players are gone. Julia Rock, good morning from Newfoundland. Awesome. Barry, with the judge saying that it was her experience that penalty phase verdicts take shorter time than guilty phase verdicts. So she basically was putting in the jury's mind subconsciously, or maybe not subconsciously, that they will be done by today. So I did not agree with that. So Samuel, is the verdict today? Possibly. We were just discussing that. The 4 defense attorneys have to give their closing arguments, which we're figuring if they're probably about an hour each. So you're looking at about 4 to 5 hours. And then jury instructions will be about another hour. 45 minutes, half hour, 45 minutes. So the jury will probably start to deliberate by 3 or 4 today. That's what we're estimating. Whether or not that happens or not, I don't know. That's what I'm kind of estimating. Beach Mom, good morning to you. How are you? Hey, Wall, good to see you. Really hope the jury goes with LWAP. Radioactive, I wouldn't trust these guys back into the community. Well, it would be supervised, obviously. You would have them supervised. I'm not saying just let them go back to the community. I'm saying they would be supervised. They would go with the pastors. They would go with their bailiffs. They would go with their officers, or they would have the kids come to the jail. Then there's that. They could always have kids come to the jail too. If you don't, if you don't trust them out and about. Heidi, the judge wants this to be the last day. Carolina says she actually said you need to bring a bag just in case. So how did she tell them it would be a quick verdict? Because she said just in case, bring a bag. All right, we got a live feed. Let's see. Do we have audio? No audio yet. But she said it's her experience that penalty phase verdicts take less time than guilt phase verdicts, which I thought was prejudicial because she's already putting in the minds that they're going to be deliberating less than they did for the guilt phase, which I just did not agree with. Surf and Selena, hello to you. Elaine, good to see you. They only need 8. That is correct. They only need 8 out of 12. 8 out of 12. All right, why don't we have audio? Let me just double check. Make sure that they're not fooling with me. Let's see. All right, yeah, no sound. No sound over there either, right? Yeah, no sound. Hey, Kimbers. Good morning. Good to see you. Stella. Good to see you. All right, now we just need the judge to turn on the volume and we'll be okay. Here we go. All right. We have the volume.
Okay, great. Yeah. It starts off. See, we start off at.
And the sound goes away. There we go, Elaine. Good morning. Hey, Camilla. Good to see you. Nicola, is it Nicola or Nicola? Do you say it Nicola or Nicola? You holidayed in Florida in the 90s. Miss Bree, I think Sean and Isaiah do have some strong positive people in their life. Knowing what they know would be instrumental in their life. She's frustrated already. I know, right? Stella, good to see you. Rock and roll, how are you? Good morning, good morning. Sounds like the jury's coming in. All right, here we go.
Jury is in judgment.
Okay, very good. Welcome back, members of the jury. We are ready to proceed. And Ms. Finkelstein, on behalf of Sean Gathright, you may proceed.
Thank you, Your Honor. Good morning. Members of the jury, we have come a long way since you were selected a little bit over 3 weeks ago, and now we have reached the most demanding part of this trial. In just a little while, the fate of Sean Gathright is going to be out of our hands and into yours. If you remember back to jury selection, there was a lot of numbers, scales, questions posed to you over and over, and I told you at that time I wasn't going to hold you to those numbers. Some of us said we didn't really like the numbers. It was just kind of getting a feel for where you guys stand coming into a new scenario. And the reason I said that was because this isn't a test. This isn't a numbers game, not a math problem or an equation. This is most literally a life or death scenario. Soon you will have to decide whether a young 20-year-old man will spend the rest of his life in prison or whether he will be executed. Sean Gathright is not wicked. Sean Gathright is not evil. No matter how many times, no matter how many ways it could be said in the state's closing, he's not a mastermind. He's not a super coordinator or orchestrator. Apparently, he might even be a rocket scientist. The state can minimize or diminish the mitigation list that's in front of you. The state may think that something deserves weight or no weight. That doesn't matter. That decision lies with each and every one of you. The state's opinion or theory is just that. This part of the trial, as I told you in opening, is about the defendants, about Sean Gathright, and it's about each one of you. On several occasions, I heard Mr. Harmon, when he was reading some of the mitigating factors that are on there, say, you can find that mitigating, that's fine. But lucky for you, you don't need permission. You can evaluate that mitigation exactly how you feel fit. Each and every one of them. This is your decision, a personal decision, and you never, under any circumstance, have to vote for death. In the state's close, Mr. Harmon presented a very strong case for why you should find Mr. Gathright guilty. You've already done that. That part's over. Went pretty hard on Mr. Gathright and painted him out as a person who led this whole thing. We wouldn't be here without him. That's his theory, and my theory is that's done to lessen the mitigation. That was done to convince you that what you saw and what you heard from this witness stand this last week from Mr. Gathright's mouth himself shouldn't be given the significant weight that it deserves. But what it actually did was prove that a kid with no motive, no involvement, no history in that, can get wrapped up in a culture that he has no business in. The evidence was overwhelming that Mr. Gathright's life has, and always will have value. Mr. Gathright is a human being worth saving. Even in prison. People may think, well, you're in there for life or death. Does it matter? You're in there. Yes, because you heard from Mr. Bonasco all the different ways that you can be useful, not only to the state from a financial perspective, if that matters, but to other people in prison, out of prison, his family that supports him no matter what, sits in here and listens every day. You heard what a positive, optimistic person he is from friends, family, guidance counselors. He can be a light in a dark place. Hopefully he can keep making people smile. Even now, from jail, you heard that he's still asking about other people when he talks to them, trying to keep them in good spirits while he's sitting in jail. While he is facing a death sentence, he's worried about other people. That's not wicked. That's not evil. The theme from those witnesses on Mr. Gathright's behalf was he was positive, he was funny, he was witty, he made people feel good. You heard that he was kind and respectful and well-mannered. And you don't just have to take the word of family and friends that know him and of course want to come in and they want to save him, they want to help him. You saw it from Mr. Gathright. That young man had the courage to get up there and face you and talk to you and try the best he could to explain his remorse, his accountability, and his worth. And when he was questioned on cross-examination and tried to get riled up, he remained respectful. That's his character. That wasn't a show. He was authentic. He was real. He was honest. He didn't get riled up. He answered every question politely, with "sir" at the end, from someone who was cross-examining him pretty harshly, and it was seeking to have you vote to take his life away. He remained respectful because that's who he is inside. That doesn't change. Now, is that the reason that you should not give somebody a death penalty? Well, that's up to you. And that's why it's your choice. But what it is, along with the other testimony you heard, is that proof that good kids, good people, privileged kids, I guess we want to call them, educated, intelligent, worldly, that those types of kids, Sean Gathright was not isolated or insulated or immune from getting wrapped up in something that he had no business in. He's an 18-year-old kid who is not immune from outside influence, curiosity. He told you himself, yes, I had a privileged life. I had people that loved me. I got to travel. I saw things. I did things. I had opportunity. And I still, after leaving that bubble, saw parts of Jacksonville, parts of a culture that I didn't know were out there. And look where he finds himself. That curiosity from that 18-year-old kid brought him right here. You know, the state said, oh, Mr. Bonasco, who testified, the prison expert, said Mr. Gathright was mature. I think everybody did. I think you can see it for yourself. He's mature. He appeared mature for his age. Well, Mr. Bonasco is basing that on a conversation at the jail for, I think it was a little over an hour. But either way, because he worked, traveled, helped support himself, cared for others, went to school, presented himself as grown, can take care of himself, that might be mature for an 18-year-old. But he's still 18. Maturity on the outside is not the same thing as being a developed adult and having life experiences, having knowledge, having street smarts. It's not the same thing. You can be well-spoken and smart and mature and still make really bad decisions. He is impressionable. He's naive. He was curious. He told you he was easily influenced. That matters. He told you himself that he was more vulnerable to influence and more likely to follow others, probably based on his lack of seeing other aspects of the culture, other aspects of Jacksonville. And we heard that it's pretty rough there. Because he was 18, he was less capable of kind of stopping and saying, wait, maybe this isn't taking me where I need to go, and seeing the end result. He doesn't have that experience or that knowledge. He told you that while he had male influences and guidance in his life, at the times that he felt it really mattered. When Brian Harrington, his stepfather, who was a great guy, divorced his mother 2020. Sean Gathright was only 15. So from 15 till he lands in jail at 18, he didn't have a steady, constant influence in his life when he needed it the most. He's not saying he didn't have anybody. He's not saying all the people that come here to support him and love him weren't really there. They were. But he's a kid. He's feeling his way through things. And it wasn't constant, and it wasn't there for him at those years. And that fact doesn't excuse any conduct. It doesn't remove accountability, but it explains how a young person with so much promise can make a catastrophic decision that could define the rest of his life. That one decision. And I told you in opening that mitigation isn't an excuse. I'm not up here to make excuses for Sean Gathright, and he wasn't making excuses for himself. He wasn't blaming anybody. It's an explanation, and it's a reason. And that's what mitigation is all about. It helps to understand what I'm sure everyone is wondering is how he got here. It's his story. He took accountability. He showed remorse. Remorse is defined as deep and painful and often long-lasting feelings of guilt, sadness or regret for past wrongdoing. Not at the moment. Most people don't feel remorse while they're doing something wrong. They feel it afterwards, and that's what you saw. That wasn't contrived. That wasn't fake. That wasn't for your benefit. It took a lot for him to get up there, and he wanted to. Accountability is obligation or the willingness, which you saw, to accept responsibility and account for one's actions, and that's exactly what he did. He was straightforward, he was composed, he was wholly authentic. And he told you, what led him there, what his curiosity did to him. And you had heard from Maurice Edwards, the state tried to say, he never, one of the mitigators was about, him, his instability or not being able to adapt. And Maurice Edwards did tell you that at a younger age, being that he had some experiences and that Sean traveled and was not as steady in a place, he has a biracial family, that he did feel some sense of instability. Where do I belong? Where do I fit in? And of course you're going to. You're traveling all over. Yes, you're seeing great things, but he's still a kid. And he admits, Mr. Gathright told you, stepped foot in the jail and immediately thought, where did my path veer? And instead of feeling sorry for himself, getting down on himself for this situation that he and nobody else that you heard from saw coming, he cracked his Bible. He told you he talked to God. And he's trying to make the best of a situation that he finds himself in. He said something that I felt was pretty profound, that he said, people are always asking God for something, praying to God to give them something or do something for them. And he thought, I can ask God what he wants from me. even in this situation, he can be a light. He can help people. He can try and turn lives around for kids that he comes into contact with, or adults. In a dark, dark place, he sees hope. He sees a future. And I'm up here asking you to see that future for him. See the hope in him. See the redemption in him. A lot of the questions of our mitigation witnesses and then some of the state's closing was thinking, oh, he's a privileged kid, he had it all. Does that mean he's not worth saving? I would submit to you that it's the absolute opposite. There's a long list of mitigating factors that you'll have in your instructions, and the state went over a lot of them. I think there's 32 for Mr. Gathright. I'm not going to read them all to you right now. But you'll have them when you deliberate. And it's a long list for a reason. It's a long list because in his short 20 years, 18 when this happened, he really made an impression on this world. So it's a long list. Imagine what he could have done if he had more than 18 years. And remember, that's just a list that we're providing you. Mitigation can be absolutely anything that you want. Anything you heard in the first phase, anything you heard in this phase, or just because you don't think that this young man deserves to die. The law says that you can find those aggravators that the state proved to you in the first phase, reminded you of yesterday. You can find that those were proven. You can find that they outweigh the mitigators, and you never have to sentence someone to death. The death penalty in this phase is not whether to punish, but how. It's not about whether Mr. Gathright will die in prison, but about when and by what means. Natural causes are at the hands of the government. The death penalty is not appropriate in this case. Mr. Gathright does not deserve the death penalty. This is the only time you have to make this decision. You can't change it tomorrow. You can't change it next week. This is it. A vote for life does not excuse any criminal behavior. It's not an excuse. It doesn't excuse responsibility for a crime. A vote for life doesn't diminish the life of Charles Jones or the loss to his family or his loved ones. A vote for life in this case is the just decision. It's the right decision for Mr. Gathright. Do not define Sean Gathright by the worst decision, the worst moment of his life. Sean Gathright is a son who's worth saving. He's a friend worth saving. He's a nephew worth saving. He's a grandson that's worth saving. He's a baby brother worth saving. He's an uncle worth saving. I'm asking you to do just that. Thank you.
All right, thank you, Mr. Petridis. On behalf of Isaiah Chance.
Thank you. May it please the court. I want to thank you again. You're going to get a lot of thank yous today, and they're well deserved. We are at the end of your service, but as I said in my opening, we are also probably at the most difficult part of your service, and we all understand that. I want to start by saying justice will be served. Isaiah Chance will spend the rest of his life in prison, punished away from society. All we are asking is that you spare his life. Death is never required. The death penalty exists for the worst of the worst. We submit that Isaiah Chance is not that. As I said, he will pay for this crime every day for the rest of his life. We are asking you to let him have that life. This is going to be a conversation about life, a request on behalf of a young man and his family, Isaiah Chance, someone from Jacksonville, lived with his mother, who sat in his grandmother's lap, who called his father all the time, went to Atlanta to be with his grandparents. A man with 3 children. That's who you are deciding about today. A man who spent every day of his life working harder than those around him, just trying to keep up and working harder to make it seem like he wasn't doing that. You heard from 6 people and a doctor, 6 people who love him and a doctor from that chair, and they told you who he is. They're asking for you to believe them and to listen to them. The law gives you this phase of the trial for a reason. You have decided guilt. We are past that. They ask you to decide who Isaiah Chance is and who he is and how he got to be that, if he's worth saving. As Ms. Finkelstein said, mitigation does not excuse. Mitigation explains. I'm asking you to look at Isaiah Chance, a full human being, and decide whether death is appropriate, if death is the answer. And death, we would argue, is never necessary. You heard from his entire family during the penalty phase, and like I said, a doctor. 7 different witnesses from 7 somewhat different vantage points, but all told you essentially the same thing. From Victoria Gray, she described his mother. She described him as quiet, gentle, close with his family, never violent. Someone who really didn't want to play football, who had goals. He wanted to be a merchant seaman, an entrepreneur. He was trying to build something. She told you him and his entire family had hobbies, I think she said martial arts, that they would do together because they loved each other and they genuinely wanted and loved to be around each other. Think about her, what it takes to raise 6 children, not on her own, but in large part on her own, in Jacksonville, and each one of them know that they are loved. Isaiah Chance clearly knew he was loved by his mother. He told you that himself through his interviews with the doctors. He told you that by how he acted with his father, how he acted with his grandparents, how he acted with his children. He got that from his mother. She gave that to him. It didn't come from nowhere. You heard from Isaiah Chance Sr., a United States Marine, who after serving came back to Jacksonville, who after getting divorced from his mother stayed in his child's life, stayed in Isaiah Chance's life. When he would help him with his schoolwork, he saw him struggling. And he said, hey, it reminded him of himself. You're like me. I struggled. Keep going. I see you. Not an excuse, but just, I see you work. I see you working. He told you something else. He said that Isaiah called him all the time. And every time he hung up the phone, he said the same thing beforehand. He said, I love you, to his dad. Every single time. Something so ingrained, it was subconscious or subconscious, but he said it. No one's listening when you're talking to your father on the phone. It's not performative. It's just something you do. And he decided at some point, like I said, maybe subconsciously, that every time he talked to his dad, he wanted to let his dad know that he loved him. That is not something, again, that he decided to do performatively. That just shows you that's him as a son. Heard from his grandmother, Elizabeth Jordan, Nana, I think she said. She said he used to sit in her lap when he was a baby, and if he could, he would do it today. She told you that her and Papa used to take the grandchildren on vacation and take them to church. They were there for the grandchildren, and when they needed Isaiah, he was there for them. She told you when Papa was sick, he was, I believe, 7 days he was in a coma. Isaiah Chance didn't call and see how he was doing. He didn't text and see how he was doing. He showed up. He stayed at the hospital until he woke up. And then when they needed someone, when Papa wanted to go home to be with his wife in Atlanta, she couldn't care for him on his own, they called Isaiah Chance. And he showed up time after time. I think it's, like a 5-hour drive from Jacksonville to Atlanta? And he made that over and over again for years, to be with his grandparents, to help take his 260-pound grandfather out of bed when his grandmother couldn't. When he was 19, 20, and 21. When most kids are thinking only about themselves, Isaiah Chance realized that when family calls, you show up, and he did that. I think that's an important part of Isaiah Chance and who he is, someone with value. And I ask you to remember that as you deliberate. You heard from Michelle Smith, his godmother. Knew him, she said, before he was born. Had a good relationship with him, and she said she would always tell him the truth. That's AC kicking on, thankfully. She supported.
Sorry to interrupt you. It sounds like the AC has kicked on, so Mr. Petraeus, just if you could try and just now it sounds like a windstorm over there. So
It's a good thing, though.
yes, it is a good thing.
You heard from Nashawn Nix, his former stepfather, his mentor. And he was someone I thought was a very important witness. He's not blood related to Isaiah Chance or his mother, obviously. Didn't have to be here. He was in Isaiah's life from 7 to 12, so a little while ago. And he built an organization whose entire purpose was identifying young men who can be reached and investing in them. And he saw many that couldn't be reached. And he showed up here. He told you when he was with Isaiah, he noticed things. He would go to school meetings. He would talk to him after school. He would talk to his guidance counselor. He noticed things the family saw as well. He was pushing for tutoring, for structure, and for support. And years later, after he was out of Isaiah's life, no longer with his mother, Isaiah Chance needed a letter of recommendation to be a merchant seaman. And he went to Mr. Nix. And Mr. Nix saw something in Isaiah Chance, and he put his reputation on the line, and he wrote that letter of recommendation for him. That's not obligation, that is not sentiment. It's a man who spent his career learning to see who people are, and he saw something in Isaiah Chance, and we're asking that you see the same thing. You heard from Miss Wade. She's known him from about when he was 16 years old to when he was becoming an adult. She said when she needed someone to house sit, when she needed someone to pet sit, and anyone who knows pets knows that that's a serious obligation, someone to let someone else watch their pet. She called Isaiah Chance. She never had any issues. She never had any trust issues. He did it every time. That's not someone you let do that unless you genuinely trust that nothing will happen. And she told you he would talk to her about his plans for life, specific plans, his goals, what he wanted to accomplish. And she plans to stay in touch with him while he's in prison. Tells you everything about what kind of person inspires that kind of loyalty. 6 witnesses, 6 different relationships, telling you 6 different years of Isaiah Chance's life, different eras, all telling you the same thing. He was quiet, respectful, gentle, loving, nonviolent. A young man who needed a little more structure than the world gives to most people. Then there's the science. Dr. Tracy Hardig, forensic psychologist. She spent hours with Isaiah Chance. She did actual IQ and academic testing. She reviewed school records going back to when he was in preschool. But before that, let's talk about what she said when she noticed him. He was quiet. He was mild-mannered. He wanted to be there. He wanted to do the tests. He was not depressed. And he kept saying the same thing essentially throughout the testing. I'm smart. I know I didn't do great in school, but he wanted to impress her. And he used some big words, and I would say he used some correctly and some incorrectly, like he did with Dr. Warner. He got a full-scale IQ of 71. That's what she got through the testing. At age 22, he reads at a 5th grade level. His math is at a 3rd grade level. The things that a lot of us take for granted in life that we get through life are genuinely harder for Isaiah Chance. Not impossible, just harder. She reviewed his Duval County school records, which I believe Dr. Werner glossed over. He had 3 tests done in school, and they all said the same thing at ages 4, at ages 10, and ages 12. 3 different other evaluators, independent. At age 4, said he had issues with speaking, and we heard from multiple of his witnesses telling you that he was nonverbal at that time. So corroboration. At age 10, he got the same score as Dr. Hardig got, corroboration. And at age 12, he was even a little bit lower, again. And then he's removed from that school. People with IQs in this range are not unintelligent. They can form relationships, they can have jobs. And we're not asking you to weigh his IQ as an excuse, but just as context, something you can weigh when you're back there deliberating on mitigation. She also diagnosed ADHD, and the clinical observations you saw from school showed the same thing. Off task over 30% of the time, way more than his classmates, and it was never treated. The state talked about a co-defendant not having IQ tests because they didn't provide corroboration, and they talked about that as a bad thing. Well, we have corroboration from 3 IQ tests, and they don't want you to look at that, and I'm asking you to look at those IQ tests that corroborate Dr. Hardig's and go against what Dr. Warner said. And the last thing I want to say about Dr. Warner is she said that she trusted the testing that was done in school, trusted the testing that Dr. Hardig did, trusted and agreed with the results of both, but disagreed with the diagnosis, which is based on the results. I would say that doesn't follow. We also heard that he could be vulnerable in the wrong environment. He has a lifelong need to belong, and that's a human, that's a character. It's not a character flaw. It's just a human need. But I want to talk about what the right environment looked like. That looked like what Mr. Nix provided. When Mr. Nix was there, when he provided structure, when someone was paying attention, made real progress. Isaiah made real progress. It tells you something. Isaiah Chance is not someone who's beyond reach. He's someone who does better when someone is paying attention. We're not here to ask you to believe that he will never struggle again. We're asking you to believe that struggle will be worth it, that he has value, that it matters, that he is not what happened in the worst moments of his life. Now, the state pointed to the aggravators. They spent a lot of time on the aggravators, and we're not here to minimize what happened, not at all. We're not here to argue those either. We're here to talk about this young man, him as a human being, about things that make his life worth saving. We're here to tell you we believe the mitigators outweigh the aggravators. Like Ms. Finkelstein said, you're going to get a list of the mitigators. I'm not going to go through all of them. I do want to go through a few of them. And you give whatever weight you believe to these mitigators. Isaiah Chance has no significant history of prior criminal activity. You heard from his mom and his dad, no arrests, nothing. His age at the time of the crime, he was 21 years old at the time of this crime. He was a young man. Like I said, he suffers from borderline intellectual disability and untreated ADHD. This loving relationship with his children, which I'll get into in a little bit. This loving relationship that you heard from his family and friends that goes both ways. Isaiah Chance did not carry, use, or threaten to use a firearm during the commission of this offense. Let me be clear, this in no way lessens his guilt. But it is a fact that you can consider when you're back there, that he did not have a firearm during this offense. And again, there's the catch-all. Anything else you heard from any witnesses on that stand that you saw, that you believe is a mitigator, you can use. Isaiah Chance is a son, a brother, a grandson, and father whose life has meaning to others. His children, Kabri, Kylan, and Amiri. His mom told you he was a great father. He wanted to be involved with his kids. Miss Wade told you he was always calling her, asking her for advice. He wanted to be involved. He was present. He was trying to be a good father. He was 21 years old with 3 kids, actively seeking out guidance to be a better father. That is not the behavior of someone who doesn't care. That is the behavior of a young man who understood that fatherhood mattered and was trying imperfectly to rise to it. He cherished his fatherhood and has a great relationship with his 3 children. That is not nothing. For a 21-year-old who may have some limitations, trying to figure out how to be present for 3 children, that effort means something. It tells you something about who he is when the stakes are personal. He showed up for his children, just like he showed up for his grandparents. It's not a legal argument. It's a fact about what it means to be human. His kids are growing up right now. One day they will be old enough to know their father, to write him a letter, to ask him a question only he can answer. And he will be in prison. But a father can still be a father behind bars. A letter, a phone call, a presence. We are simply asking for you to leave that door open. 7 people testified in the penalty phase. 6 who have known him parts or all of his life, and a doctor. Dr. Hardig told you the clinical side. People like Isaiah are a little more vulnerable. They want to belong. They want to follow because it's safer than the alternative. He spent his entire life working harder than other people, failing and trying again. He put his family first and truly sacrificed on multiple occasions when it mattered. He sat in church with Nana and Mr. Nix and talked about God and life. He was a great brother and a great and attentive father. He was someone's son, someone's grandson, someone's father. He's a human being with limitations and with love. You heard about the continued support he will get while in prison. On behalf of his mother, who raised him with structure and love, his father, who is there for his son and still wants to be there for his son, Elizabeth Jordan, who he sat in her lap his entire life, and Nashawn Nix, a man who owes him nothing but showed up here to tell you that he loves him, and he better know that he still loves him. We are asking you to spare his life. The family did not need to come here. They chose to. They sat in the witness chair knowing everything that you know, and they want to tell you that this person is not beyond saving. They're not in denial. They know what happened. They still came here and they're still asking. That says something about Isaiah Chance that no test score or school record can fully capture. It tells you the people who know him best, who have seen every version of him, have decided he's worth fighting for. And we are asking you to agree with them. The death penalty is reserved for the worst of the worst. And we would argue that Isaiah Chance and the facts of this case do not meet that criteria. He's not the kind of person for whom there's no threat of redemption or no evident conscience that the death penalty was designed for. Death is never required. Again, as I say in my opening, the law favors life because it always gives you the opportunity to give mercy. We are asking you to consider that a person can do something unforgivable and still not be beyond the reach of mercy. Isaiah Chance will spend the rest of his life in prison. He will carry what happened to him every day. We are not asking for you to forgive what happened. We are not asking you to forget it, minimize it, or look away. We are asking you to look at the full human being, everything I've talked about and everything you've heard from the stand, and decide that death is not the answer. Justice will be served. He will spend his life in prison. Today's the last day he's going to wear street clothes. Last time we'll put a suit on. Mercy does not mean forgetting. Mercy means choosing deliberately and with full knowledge what you know to let someone live. The law gives you that option. Gives you the option for a reason. We are asking that you use it. We are asking that you spare Isaiah Chance's life. Thank you.
Okay, very good. Ms. Toomey, on behalf of Davion Murphy.
Good morning. Davion Murphy was born January 10th, 1997. A blank canvas, wide-eyed to the world, not knowing his limitations, not knowing good from bad. But children learn what they see every day. When children learn criticism, they learn to condemn. When they learn hostility and violence, they become violent and fight. When children live with instability, they become unstable. Now, as I told you in my opening, Florida has no parole. There's no gain time. As Davion Murphy sits there now, and all of these other defendants, they will be given life in prison. The only question for you is when he dies, either by natural causes or by execution. That's the only decision that is left to make. And this is probably the most important decision that you will make in your life. The fate of another human being is in your hands. I want to pose a question to you, and that is, what good comes from executing Davion Murphy? It seems like a simple question. It's not so simple. I think it was Gandhi that said, an eye for an eye eventually leaves everyone blind. There is no need to execute Davion Murphy. Life in prison, a life along with thinking about this every single day, perhaps even maybe walking down the same hallway as his father, stomping the same concrete in those hallways in the Florida Department of Corrections as his father, his uncle, his younger brother that testified, his blood cousin, Rashad Murphy. A vote of death will only be the next statistic in this gang war that started in Jacksonville. It'll be just another statistic. And what comes from executing another human being? Nothing comes from it. It's not going to bring Charles Jones back. It's not going to change the events that occurred on June 23rd of 2023. It simply perpetuates the violence that started long, long ago, not here in Hillsborough County, but in Jacksonville. As you heard from the state's witnesses, the detectives, the gang detectives, so much violence so in these gangs that they have detectives that are given certain gangs to follow. That's what Davion Murphy grew up in. He grew up in East Jacksonville. Davion Murphy wasn't born into a life of privilege and opportunity. He was born into violence and instability. What chance did he have? And folks, I'm not offering you an excuse for these events or what happened. It's tragic. I'm simply offering you context of the facts. Context. Davion Murphy was 12 years old when his father, who suffered from schizophrenia, was given life in prison for murder, along with his uncle, his parental uncle, who also was given 50 years in prison for murder. When he was 12 years old, his father was gone, absent from his life. And you heard from his youngest brother, Adam Gooden, his youngest brother, who broke down in front of you all. Well, they grew up in the same environment. They had the same mother. They had different fathers. But if you recall, Adam Gooden also told you that his father was incarcerated in prison. This is a generational violence, instability, insecurity that these men grew up in. When I say these men, I mean Davion and his cousin. And you got to see this firsthand through the state's witnesses, their detectives, as well as through the individuals that testified on Davion's behalf. Take a technically, intellectually disabled child with learning disabilities, throw him into the violence and crime in the streets of Jacksonville. What happens? They look for comfort. They look for a father figure. What becomes the father figure for them? The streets, the gangs. Now, as you saw, not only did Dr. Eisenstein, and we'll get to that in a moment, but Dr. Eisenstein testified that he was borderline intellectually disabled. They had long ago indicated that Davion Murphy had a mental disability. He was in special classes, he was in IEP classes, he had to repeat various grades, and he also suffered traumatic brain injury from all the various events that occurred in his life. Multiple motor vehicle accidents, fights, falling off a golf cart, or running a golf cart into a tree. And folks, these scans, these images weren't done because he was found guilty. The state knows better than that.
Judge, objection, that's an improper statement. It's a misstatement of the law, and that's improper.
I'm going to sustain the objection.
These scans were done to show you that Davion Murphy suffers brain damage. What does Dr. Rubino have to come in here to risk his medical license to say, and you saw the scans, and you can take it back if you want to look at them, to say that he suffers from brain damage? And the state had its radiologist, a diagnostic radiologist, of whom I respect, Dr. Glickstein, I respect, but he doesn't have the knowledge and the upkeep of the new technologies. He wasn't able to, he hasn't seen he said, I think it was like once an MRI, DTI, which is commonly done in these radiology facilities. Why would a neuropsychologist recommend scans that a neurologist send to a radiology facility that then conducts the scans and gets those images, perform those? It's a big liability there. I suggest to you that he does have brain damage. You can watch the interrogation video yourself. That's demonstrative evidence of the state of mind of Davion Murphy and his intellect. Now let's talk about a little bit about mitigation. As you've heard, it's not a numbers game, it's not a calculation, it's not who's got more mitigation. It's about the weight and the significance of that mitigation. I'm not going to address the aggravating factors. I'm not going to waste your time. I'm not going to insult any one of you. But the mitigation that was presented on behalf of Davion Murphy is substantial and is great, and it deserves great weight. And you also have to remember that the mitigating circumstances have to be proven, not beyond a reasonable doubt, but by a preponderance of the evidence. I submit to you that Dr. Eisenstein, who met with Davion Murphy 7 times in person over the course of 6 months for over 20 hours, has a better idea, a better understanding of what Davion Murphy is about, not Dr. Warner, who met with him by Zoom for 80 minutes. And then when asked by the state about why she had such limited time, was because the jail only gave her 3 hours or something like that. Well, if you only had 3 hours, then say you need enough time. You didn't have enough time. You can't render a proper diagnosis or render an opinion because you didn't have enough time. Dr. Eisenstein had enough time. He took the time to know Davion Murphy, went through his records, his medical records. And why did we not provide Dr. Eisenstein with police reports, videotape interrogation, videos and such? Because we wanted to make sure that there was no bias, that Dr. Eisenstein met with Davion Murphy without any bias in his mind. That's why. I suggest to you that Davion Murphy's life is worthy. Davion Murphy is worthy. That he is redeemable. That he's made a grievous mistake. And that he should be punished. He will be punished. He's being punished every day. And he will be punished every day for the rest of his life. There's no doubt. But it's your job to look at him as an individual, all of these defendants as individuals, and not compare one to the other, but look at each of them as an individual person, and then decide whether the mitigation, which has a lower burden, and rightfully so, has been proven and substantially or outweighs the aggravation in this case. It has to make the crime more grievous. It doesn't. Life is the appropriate sentence. There's nothing that a death sentence is going to do in this case. So the mitigators that you have on behalf of Davion Murphy is the capacity of Davion Murphy to appreciate the criminality of his conduct or conform his conduct to the requirements of law. That's one. He's got 13, but once again, it doesn't matter. It doesn't matter if you've got 50 or if you've got 100 and it's not a numbers game. It's not who's got more or who's got more aggravators versus mitigators. The second one, the capital felony was committed while Davion Murphy was under the influence of extreme mental and emotional disturbance. That's where Dr. Eisenstein comes in. That's where Dr. Rubino comes in with their testimony. The age of Davion Murphy. He was 27, but when you consider the testimony of Dr. Eisenstein, the age of the person on the outside isn't necessarily the age of the person on the inside. Davion Murphy suffers from traumatic brain injury. Yes, Dr. Rubino testified that he did. And doctors, they disagree. They do disagree. You have to decide who you believe. And once again, we don't have to prove beyond a reasonable doubt that these mitigators exist. Just a preponderance of the evidence, greater weight of the evidence. Davion Murphy is in the borderline range of intellectual disability. Let's talk about Dr. Warner for a minute. She indicated that he was low average, I think is what she testified to. But she's doesn't have the ability to do any psychological testing, didn't do an IQ test, didn't do really basically anything. She did a mental status examination of Davion Murphy. That was not rebutted, wasn't disproved. Davion Murphy did not have a stable role model in his life. No, he did not. Neither did his younger brother. Davion Murphy's father was diagnosed with schizophrenia. Yes, you heard from Winston Murphy, who was very reluctant to testify, but yes, that was his brother, and he testified that his brother, who is Davion Murphy's father, was diagnosed with schizophrenia. Davion Murphy's father was incarcerated for life when Davion Murphy was 12 years old. Yes. Davion Murphy took on a parental role for his younger siblings. Yes, because he had to. Adam Gooden testified that he had to sell, or they would sell a PlayStation or something like that to get food. Davion Murphy is loved by his family. Yes, yes he is. And then the existence of anything else. That means that mitigation to you can be anything else that you decide it to be. You get to decide. Maybe it's something I didn't say or wasn't presented to you. Maybe it's something that just because. Just because you think life is more appropriate than death, than execution. Because this vote is individual to each one of you. It's an individual moral judgment that each one of you have. Yes, you have to go back and discuss the evidence and things, but it's your vote. It's not anyone's vote, and don't let anyone else try and convince you of what your vote should be when you go back there. It's your decision. Folks, gang violence tears apart families, neighborhoods, and futures. And that's exactly what it did with all these families, Charles Jones' family. The death penalty only guarantees that suffering and that violence continues. Life in prison for Davion is a just punishment. It removes him from society. And we can be tough on crime without the death penalty and just giving him life in prison. Now this is the verdict form. And once again, just like in the guilt phase, excuse me, just like in the guilt phase, just because you didn't hear from Davion Murphy, like you heard from Sean Gathright in the penalty phase, doesn't mean you can hold that against him. He's got the right to remain silent, and you cannot use that against him. Just want to remind you of that. Or any of the defendants that did not testify in the penalty phase. But here's the verdict form. It's 3 pages long, but on that second page is where it has jury recommendation. And you might think, well, it's just a recommendation. It is, but your recommendation will be given great weight by the court. So when you vote, it's going to be the vote. It's going to be the deciding factor as to what these individuals get, life or death. If fewer than 8 jurors vote for the death penalty, your recommendation must be for the penalty of life in prison without the possibility of parole. Fewer than 8. That means 7 of you can vote for death, 5 of you can vote for life, and they would get life. I submit to you that you really don't need to even get there, folks, because you could just go right to the bottom and find that Davion Murphy should be sentenced to life in prison without the possibility of parole. That is a just punishment in this case. This is not the most aggravated of murders and the least mitigated. What good would it do to execute an intellectually challenged, brain damaged 29-year-old male who's grown up on the streets of Jacksonville just trying to survive the gangs and the violence? He lived and did what he saw every single day. he's going to be punished enough. You can tell Davion Murphy that he did a terrible thing. This is terrible. It's tragic. But you can also tell him that he's redeemable and he has worth with a vote for life. Thank you.
Thank you, Ms. Toomey and Mr. Hernandez, on behalf of Rashad Murphy.
Please, the court.
Yes.
Counsel. Good morning, ladies and gentlemen. I want to begin again by thanking you very much for your service, your attentive service in this case. As you know, I am speaking on behalf of Rashad Murphy. I cannot imagine an attorney having a more overwhelming responsibility than advocating for a man's life. And here we are. As we go through the evidence that was presented and the mitigating circumstances that have been proposed, I want to make sure that there is no attempt to misstate. If I say something, I've got notes, you have your notes. If I say something that you remember differently, please rely on your notes and your collective memories. You've heard it several times during this case, and I'll go briefly through it. Your recommendation is extremely important. It carries great weight. The judge has to give it great weight. And the mitigating circumstances that have been proposed by Rashad Murphy and the other defendants only have to be proven by the greater weight of the evidence. If you believe that it more than likely exists, you can consider it and give it the weight that you decide it deserves. And those mitigating circumstances can be facts about the case, or it can be facts related to Rashad Murphy as a person, as a human being, such as the mental issues that have been presented, his childhood, his history, his accomplishments. It can also be your personal observations of Mr. Murphy's behavior during the last 6 weeks, as you've had a chance to observe him for 6 consecutive weeks. And your vote, although you deliberate, each vote is individual. And although there is a weighing process, you ultimately are being asked to decide what is the appropriate vote, either a life recommendation without the possibility of parole or death. Ladies and gentlemen, nothing that I am saying during my closing arguments is designed to in any way minimize the tragedy for Charles Jones and his family. Death resulted regardless of the details. His family, the family of Mr. Jones, grieves regardless of the details. All that is a given before your analysis in this penalty phase begins. And the same principle applies to the crime of murder. All murders involve some level of violence, some less, some more, but they all involve some level of violence. All first-degree murders involve either premeditation or while committing a serious crime such as robbery or rape. Nevertheless, and that's why we're here, nevertheless, not all first-degree murders warrant the death penalty. And I submit to you that in the case of Rashad Murphy, the death penalty is not warranted. But we need an analysis of the facts of the case, but also of the person who Rashad Murphy is. You heard from several family members. You heard from his fiancée, Charmaine Staker, and the mother, his fiancée, that they've known each other for, I believe, 15 or more years, and the mother of his 4 children. You also heard from 2 of his aunts, Hazel Dickerson and Jamila Murphy, as well as his uncle who's in prison, who testified here as well, Winston Murphy. They all made it clear to you that they love him very much and that he has a lot of redeeming qualities. They all confirmed, in one way or the other, they all confirmed Mr. Murphy's difficult childhood, his personal history, being an excellent father and brother to his siblings. They all had some knowledge, some more, some less, of the physical and emotional abuse that Rashad Murphy suffered growing up, that he witnessed gun violence and lived in a high crime area, that he was raising 6 children when he was arrested in this case, his 4 children and 2 of his younger siblings. And despite working and having a limited income, he was raising 6 children. You heard that he was consistently employed, and that you also heard from Ms. Steger, his aunts, that they would continue to have contact with Mr. Murphy and visit him in prison as he would be serving if he ultimately gets a life sentence without the possibility of parole. And with something that Mr. Harmon said yesterday, I want to make it clear, and I think you would agree. The fact that he has some loving family members, such as his fiancée, but going back to his childhood, having 2 loving aunts, does not in any way erase the extremely difficult childhood that he had without a father and with a mother with a serious drug problem. And obviously he was taken out of the family home and placed into foster care because of that. You also heard from Dr. Collins, a licensed psychologist. He testified and has previously testified as an expert in neuropsychology. He was appointed by the court and paid by the state of Florida. He was asked by me to evaluate the defendant, Mr. Murphy, and possibly testify in this case, which he did, obviously. Before he testified, he was provided reports, not everything in the case, but provided records to review. Some about the case itself, so that he would have a sufficient amount to become familiar with the facts of the case and the evidence in the case. But also about the defendant, before he even sees the defendant at the jail, things that would give him knowledge of the defendant as a person. His background, his childhood history, his mental history, jail records, because by that time he's been in jail on this case for a period of time. And then he has contact with the defendant on 2 occasions. I believe his testimony that he ultimately spent a total of 7 hours with Mr. Murphy. Part of that contact is to interview him, just chit-chat, have a conversation with him. And the purpose of that is to get to know him, to find out, to determine whether he is going to be cooperative and whether he is going to provide truthful information, because whatever he says can be compared to records that he's had a chance to review. And then part of that time is to conduct psychological testing, standard accepted test to analyze and diagnose. Dr. Collins testified, and none of this really is being refuted by the state. He was cooperative. There were tests done to find out if he was in any way faking and malingering. That was not the case. He was definitely cooperative and not malingering. The important thing, or at least one of the important things, is that the interview, the testing, and the records that were reviewed by Dr. Collins were all consistent, clearly indicating that Mr. Murphy was being truthful regarding his self-reporting about his childhood, about his background, about his history, and about his mental state. Dr. Collins testified that Rashad Murphy suffers from anxiety and depression stemming from childhood trauma that would be intensified throughout his adulthood. That he, Rashad Murphy, was physically and emotionally abused by his father, by his stepfather, and in the foster home. And that his mother suffered from severe drug addiction and ultimately died, where leaving Mr. Murphy with having to, by this time he's of course out of the foster home, and having to take care of his younger siblings. He confirmed, Dr. Collins confirmed, that drugs and violence were common in his community, in the community that Rashad Murphy grew up in when he was not in foster home. Ladies and gentlemen, I'm trying not to be repetitious, but the fact is that Rashad Murphy was born into violence and suffered a lot of abuse and neglect. He was removed from his father's care by the state when he was a small child. And all of this is confirmed by Dr. Collins, not just talking to Rashad Murphy, but looking at all the records. And then, as I said a minute ago, is that back after, I think it was 2018, when his mother died, he adopted his younger siblings. He was employed, but obviously a limited income, trying to not only financially support his fiancée, his 4 children, but also his 2 younger siblings. Dr. Collins also confirmed other records, and of course you've heard from Ms. Steger, that he had a loving relationship with his childhood sweetheart and mother of his 4 children, that he was an excellent father, hard worker throughout his adulthood. The diagnosis by Dr. Collins is that Mr. Murphy suffers from post-traumatic stress disorder, PTSD. And as you know, it's a mental condition triggered by experiencing and/or witnessing terrifying events. And it disrupts daily life. It affects his judgment, his decision-making as an adult. And it goes back to his childhood. Once someone has PTSD, it doesn't magically go away. It can be treated with psychotherapy and medication, but his condition is always there and does not go away, and it relates back to his childhood. And again, I should point out that, and I'll get to it in a minute, that Mr. Harmon, on cross-examination, I think, tried to discount it somewhat, but there was never anything presented by the state refuting this diagnosis. There was also the fact that his father, Rashad's father, had mental problems. That was documented. And also that Mr. Murphy's condition was noted in the jail records by state doctors before Dr. Collins even got involved. So you have corroboration that is and not disputed by the state, discounted, but not disputed. There's no expert saying otherwise. You also, through the testimony of Dr. Collins, you heard that several examples of Mr. Rashad Murphy trying to help himself, better himself as a person while in prison. Ladies and gentlemen, that evidence has more than one indication. I suggest to you that it does show that he's trying to better himself as a person, but it also shows that it's indicative of him not being a troublemaker, adapting to prison life, following strict rules and regulations, that if he was sentenced to life in prison without the possibility of parole, he would not be a problem, a troublemaker in prison. He's been in jail 2 years without any problems. And as I said, trying to better himself, you have the exhibits that you can look at when you go back to deliberate. There were 3 composite exhibits presented to you. One is Defense Exhibit 1 dealt with education. He got his GED while in prison, while in jail, not prison. He got his GED while incarcerated on this case. He also, there's a series. Defense Exhibit number 2 has several, I forget how many, 8 or 9 attached to that exhibit about different religious certificates and classes that he's attended, different religions, just showing religious awareness. But it also was presented during the testimony that he not only has been taking these classes, he has been teaching some of these classes to other inmates. He serves as a mentor in prison, in jail. I keep saying, I don't mean to say prison, Hillsborough County Jail. And then Defense Exhibit number 3 is a composite of certificates dealing generally with self-help, parenting classes, dealing with Alcoholics Anonymous, emotional regulation, things of that nature. And ladies and gentlemen, I think what I'm saying, it feels it's too obvious to mention. None of this testimony and exhibits are offered as legal defenses or excuses for the homicide. But as you know, all first-degree murders are inexcusable. But they certainly are offered as valid mitigating circumstances showing that the defendant, Rashad Murphy, has many redeeming values, showing that a life recommendation is appropriate. The court, when we get to part of the instructions, when we get to specifically Rashad Murphy, the defense is offered to you a series of proposed mitigating circumstances, and that they will be read to you. One of them, and I think there's a couple that have to do with the fact that he has no prior criminal history, and we'll talk about that in a minute. No prior felony convictions. There's also a couple, they're kind of interchangeable, that Rashad Murphy, his age at the time of the offense, he was only 30 years old when the homicide occurred. There's no dispute of this. It's there for your consideration. The state never is not disputing it. It was stipulated to. Another proposed mitigator is Rashad Murphy has a history of physical and emotional abuse as a child consistent with childhood post-traumatic stress disorder. You heard from Dr. Collins, you heard from the record from the jail doctors, I think there's certainly corroboration of that, and again, something that has not been refuted by the state. You will also hear that Rashad Murphy has maintained a loving relationship with family and friends while incarcerated. And again, you heard that from the fiancee, Ms. Steger, his uncle, and his aunts. Another proposed mitigator is that Rashad Murphy has developed religious and spiritual awareness while incarcerated. In fact, you heard testimony that he was religious before, but certainly the exhibits and his family's testimony corroborate that. Also, Rashad Murphy helped raise his younger siblings, including working jobs at a young age to provide family support. Certainly that was corroborated by the records and by the testimony of his family. And the same thing with the next one, which is Rashad Murphy as a minor was removed from his primary home and placed into foster care due to negligent and abusive situations in the primary home. Also, Rashad Murphy has displayed appropriate behavior and the ability to follow rules while incarcerated. And again, that's corroborated not just by the exhibits and the records. He has been no problem whatsoever while he's been incarcerated. And that's an indication of what type of prisoner he would be if he is sent to prison for life. You also are being told the existence of any other factors in Rashad Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death sentence. And we'll get to, I will touch base on some of these mitigators, but if there's something I forgot, something that you believe in your observations or hearing, please rely on that as well. Now let's go back to some of these. His age, which is two of the proposed mitigating circumstances. He was 30 years old at the time of the homicide. He's presently 32 years of age. To some extent, I would suggest that that age is an interesting number. He's still a young man. He's still a young man. He was only 30 at the time of the offense. And it certainly, that alone is offered as a significant mitigating circumstance. However, it also is old enough to have established a pattern, good or bad. It's certainly at the age of 30, you've been an adult for 12 years. It's certainly old enough to have become a career offender. But here we have no felony convictions whatsoever. So here we have 12 years of adulthood to look at, and we have a good pattern. With his background and an environment, with the violence surrounding him, with the abuse inflicted on him, I suggest to you that it's extraordinary that he made it to the age of 30 with no criminal history. Let's go back a minute to the PTSD. As I said before, the state is not refusing the mental condition. And no state doctor testified saying, refuting the opinion of Dr. Collins. I think it's fair to say that the state is suggesting that considering everything, it's not important because you found the defendant guilty of first-degree murder. And as I said before, it's not offered as a defense, but it is presented to you as a significant mitigating circumstance for your consideration. And I think it's somewhat disingenuous for the state in their cross-examination to imply that the defendant's mental condition is normal for someone who's incarcerated. Of course, being in jail, getting arrested, got to be stressful. But that's not what we have here. The defendant's childhood is not normal. Getting abused by his father and stepfather is not normal, ladies and gentlemen. Growing up in the violent environment is not normal. Being abused at the foster home is not normal. Neglect due to his mother's addiction is not normal. Touching back briefly on his behavior while he's been in jail on this case, and as I said, it shows that he knows he's not he doesn't cause trouble at the jail. But I think it should be emphasized that he can be, in addition to having contact with his family, he can be a positive influence on other prisoners. He's been teaching Bible classes. He can mentor other inmates now in jail and later in prison. And as I said, he would, as you've heard testimony, the evidence has shown and his behavior has shown that he would continue to be able to maintain a living relationship with his family and friends while in prison. Ladies and gentlemen of the jury, all first-degree murders are not the same. That's just the bottom line. And that's a decision, a vote that you have to consider. The facts and circumstances are always different. All defendants convicted of first-degree murder are not the same. And, of course, as a corollary to that, not all first-degree murders warrant a death sentence. I suggest to you that the death sentence should be reserved for the worst cases. All murders involve the death of a human being. All murders involve some level of violence. But here we don't have any torture. We don't have multiple deaths. Here we don't have separate incidents. It was all one event, a terrible event. I mean, there's no way to describe it otherwise. A terrible event, but only one contemporaneous event. You determined justice. You determined justice was served with your verdict. As you've been told more than once, Rashad Murphy will die in prison regardless of your vote. And based on your verdict, a severe punishment is appropriate, and there's only two choices. I submit to you that justice will be served. It will be further served by severely punishing Rashad Murphy by making him spend the rest of his life, which, according to normal life expectancy, could be another 50 years, to spend the rest of his life in prison, to live under strict rules and regulations without the basic freedoms we normally take for granted, that we normally enjoy. And I'm trying not to be repetitious, but I need to go back for a moment to this lack of any prior felony convictions. I cannot, ladies and gentlemen, I cannot overemphasize this. Despite the terrible environment the defendant grew up in, despite those scars, despite the mental ill issues he lives with on a daily basis and will continue to live with, despite whatever treatment he gets. The defendant, Rashad Murphy, has no prior felony convictions, not one. And I ask you, when you decide on your vote, compare that fact, that stipulated fact, to a career offender. Compare that fact to someone who has a prior record of similar crimes or violent behavior. Compare that stipulated fact to the state's argument that the attempted murders serve as an aggravating factor despite being only one contemporaneous event. Compare that stipulated fact to the state's argument that an aggravating factor is that the defendant was a criminal gang member. All that, all those allegations, all those factors, despite the fact that he has no prior felony convictions. I submit to you that the mitigating circumstances outweigh any aggravating factors presented by the state. But in any event, I submit the mitigating factors clearly show that a life recommendation is warranted with respect to Rashad Murphy. Ladies and gentlemen of the jury, I have not offered this evidence or made this closing argument to in any way justify the homicide. My only point is that the evidence presented, all corroborated, demonstrates that a life recommendation is appropriate for Rashad Murphy. And finally, I want to talk about Rashad Murphy's children. 2 sons, 2 daughters, between the ages of 7 and 13. Pretty much the ages that the defendant was when he was experiencing some of this abuse and separation from his family growing up. Despite being in prison for the rest of his life, he was an excellent father, he is an excellent father, and he can still be a positive influence on his children. He has been and would continue to be a loving and supportive father. Please let him carry on as daddy to Major, to Avery, to Prosper and Gabrielle, guiding them to do the right thing. Thank you.
All right, thank you, Mr. Hernandez. Okay, we're going to take just a quick comfort break, and then we're going to come back. I'm going to read the final set of instructions to you, okay? All right, thank you.
All rise. Jury is out, Judge.
Okay, very good. All right, take a 2-minute break, and Ron, when they come back in, if you would hand these out to them.
Yes, Ron.
All right, I'm surprised that they are done. They started. It's like basically an hour, basically between the 4 of them. So for those keeping track at home, Jenna Finkelstein, and on behalf of Sean Gathright, was 19 minutes and 15 seconds. So basically 20 minutes. Justin Petraeus, on behalf of Isaiah Chance, was 17 minutes and 32 seconds. Deborah Toomey, on behalf of Davion Murphy, was 22 minutes and 56 seconds. And then Daniel Hernandez, on behalf of Rashad Murphy, was 32 minutes and 20 seconds. So Sean and Isaiah were basically close. Davion was a little bit longer, and then Daniel for Rashad took the longest, over half an hour. I honestly thought they would talk longer, but I guess there's only so much you can talk about, right? So, all right, so we're going to get to jury instructions next, which I was thinking would be like a half hour, 45 minutes. So that will, so 11:30, yeah, by lunch, certainly by 12, definitely by 12, I think they will be deliberating. So we will, it's a pretty strong chance they'll have a verdict today. They took around 7 hours, I think, for penalty phase. 7 hours and 36 minutes, so seven and a half hours basically for the penalty. And I don't disagree with what Judge Sisko said yesterday about taking less time. We did cover Jose Soto and Jose Soto Escalara, and they took about the same time. DeMorris Hunter, they took far less. DeMorris Hunter was 7 hours for guilt and then 2 hours to come back, and it was a 12-0. They put him on the row in less than 2 hours. So in the two DP cases that we've covered, one was about the same from guilt to penalty. The other one was significantly less from guilt to penalty. So I'm not necessarily disagreeing with her. I just was yesterday, I'm like, I didn't think that was necessary to say. To me, that was prejudicing the jury, or planting that seed in their mind. But I would fully expect them to come back with a verdict, especially if they start deliberating at 12. Remember, they only need 8. You don't need to be unanimous. You only need 8. So 8 out of 12 is probably going to happen. So, all right, we should probably get a poll going, right? Let's get a poll going. Wizard saying, let's see, we'll get a poll going. After jury instructions are read, jury goes to the room to deliberate. Yeah, for sure. How long are they going to last? I think we should just get that going right now. Well, she still shouldn't have said that. I know. Just prejudicial. Yeah, it just didn't sit well with me. I don't know. Just didn't sit well with me. Debbie, maybe all his head injuries were when he was drunk, DWIs. Well, we know he crashed. This is Davion. He crashed his head, he was driving a golf cart when he was 14, and he crashed that and hit his head on the steering wheel. Then he was fleeing. He stole a car, and he was fleeing officers, and he crashed then, had to be taken to the hospital. He says fights, drinking a bottle of tequila probably didn't help either, but, let's get a poll going now. Why don't we get a poll going now? How long do you think they'll take to deliberate? Because I thought they would start at like 3. that was my guess. I thought they'd start at 3 or 4, but clearly I was wrong on that. All right. How long will the jury take to deliberate? I'll even say today. How long will the jury take to deliberate today? All right, we'll go with 0 to 1 hours. We always have to do that. 0 to 1 hour. 0 to 1 hour. 1 to 2 hours, 2 to 3 hours, 3+ hours. We'll just start with that, 3+ hours. All right, 0 to 1, 1 to 2, 2 to 3, 3+. I wish I had more fields. I only have those 4 fields because I'd like to go 3 to 4, 4 to 5. But anyway, we'll start with that. All right, how long do you think the jury will take to deliberate today? All right, new poll for you guys. New poll for you, chat. There you go. And what time is it there, Simpin? It's 10:44. So right now, local time is 10:44 a.m. So right now, it's 10:44. Horse Welfare's posting, 10:44. 10:44. Oh, Florida PI Sam, are you with us? Where are you? Did you slide in? I don't see you. There you are. Florida PI Sam, just stopping by to say hi from Ohio. Hope you will join us tomorrow night. Yes, so tomorrow, as Aaron posted, tomorrow Florida PI Sam is going to be doing a live, and I will be a guest over there. So please please join Florida PI Sam. I will be a guest over there, and it'll be fun. We'll have a really good conversation about the penalty phase. Sam's going to do a final breakdown. We'll break down the final phase of the Julio Foolio case, the penalty phase. That's going to be at 7:15 Eastern. So definitely join us. Join us over there. If you haven't already subscribed, definitely go check out Florida PI Sam. She does great work, and I'm excited to be joining and talking. And I don't have to do anything other than just show up and talk. I'm just going to show up and talk. Logan, good morning. Good to see you. And good vibes. That's good. It's poll o'clock. I like that. That's good. That's a good one. It is poll o'clock. Jenny G in the house. How are you? Thank you for joining us. Woohoo. Yes, let's get our likes up. We have 189 likes. So if you hear my voice, please take this moment before we come back from break. Take a moment and hit the like button if you have not already. Please let us know that you're out there and you can hear me, and you support this content, and you want to have justice for Charles Jones. We have we have 154. Sorry, 155. Yeah, let's see if we can get those likes up. I was looking at the one from yesterday. Right? Yeah, 155 likes. So, Downey Lynn, fantastic. You subscribed. Fantastic. Good. Little mama smacked it. Nice. Camilla says, court's instructions. 1, watch. 2, enjoy. 3, hit like. 164. Awesome. Yes. Let's see if we can get it up to 200 before. Dan B, thank you for that. Tammy in KS, never right on these polls, so you're going with 3+ hours. I'm going with that too. I would go with 3+ hours. I'm thinking maybe like 4. If they start at noon, they can deliberate while they're eating, while they're having lunch. So if they start at like noon, which seems like they'll probably start around noon, I would say 4 or 5 hours. I think before the end of the day. Probably before the end of the day. Ali Lee, thank you for your support. Appreciate that. Thank you, Wizard of Ezzy. Appreciate that. Sub to Florida PI Sam. Awesome. Debbie, thank you for the 5 Trial TV Live gifted memberships. Mr. G. Fetty, awesome. You got one. Who else is with us? Anybody else with us? Anybody else in our chat get one? Thank you for that, Debbie. Appreciate that. That's awesome. Hellriders thinking 2 to 3 is good. Welcome in new members. Welcome in. Awesome. Dan, subscribed, got gifted a membership. What a great life and community. Oh, that's it. Were you on this list right here? I didn't see your name. All right, you got gifted from another one. Awesome. Cool. Joanne saying, thank you, Debbie, for your generosity. Welcome in new members. Mr. G. Fetty, there you go. So you can enjoy the soundtracks. Aaron makes some really great soundtracks, so you can go listen to those. We have cooking videos. We have members-only notes. You can check out my notes. We post those for members only. There's some videos of some cats. There's all kinds of things. But definitely go and enjoy the perks. Enjoy the perks. Thank you, Logan. Appreciate that. Oh, 173. Good job, you guys. Thank you for that. Wizard went with 2 to 3 hours as well. Hellrider, welcome to the best chat on YouTube. Awesome. Blackmon's Black. It's Friday. They get out of there early. 45 minutes. Wow. Yeah. Hey, it could happen. I don't know how intense the verdict form is. Remember the other verdict form? It's for each 4, right? And we looked through a generic verdict form for the PI. Sam and I did that last week.
State's present. Let's go ahead and bring in our jury.
Scott says, what do you think the verdict will be? Well, the verdict is they've already been found guilty. The penalty phase, it's not looking good. It's not looking good for them. I'll go on the record saying it wouldn't surprise me. It's a jury. You just don't know. You just don't know. Maybe some will get. We've done a couple polls of what do you split. Some may get life, some may get DP. So I'm just saying it's not looking good for them. So it wouldn't surprise me. That's all.
You ready?
All right, here we go.
All rise, doors enter.
Okay, very good. All right. I believe you all should each have a set of the final instructions before you, so you can read along while I read them to you. Members of the jury, you have heard all the evidence and the arguments of counsel. Now you must decide whether each of these defendants should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state as to defendant Isaiah Chance are, number one, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Number two, the first-degree murder was committed by a criminal gang member. The aggravating factors alleged by the state as to defendant Sean Gathright are: 1. Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. 2. Sean Gathright knowingly created a great risk of death to many persons. 3. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions are the same with regards to cold, calculated, premeditated, and pretense of moral or legal justification. The aggravating factors alleged by the state as to defendant Rashad Murphy are: number 1, Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Number 2, Rashad Murphy knowingly created a great risk of death to many persons. 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions of cold, calculated, premeditated, and pretense of moral or legal justification are the same. Number 4, the first-degree murder was committed by a criminal gang member. The aggravating factors alleged by the state as to defendant Davion Murphy are: number 1, Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. 2. Davion Murphy knowingly created a great risk of death to many persons. 3. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions of cold, calculated, premeditated, and pretense of moral or legal justification are the same. Number 4, the first-degree murder was committed by a criminal gang member. You have heard evidence about the impact of this murder on the family of Charles Jones. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by the death of Charles Jones. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction it is one which is not stable but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each of the alleged aggravating factors exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find that each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt as to a defendant, then that defendant is not eligible for the death penalty, and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt as to a defendant, then that defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of a defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is a defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances need not be proven beyond a reasonable doubt. Instead, a defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether a defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are mitigating circumstances as to defendant Isaiah Chance. Number 1, Isaiah Chance's age at the time of the offense. 2, Isaiah Chance has no significant history of prior criminal activity. 3, Isaiah Chance was 21 years old at the time of the offense. 4, Isaiah Chance suffers from borderline intellectual disability as well as untreated attention deficit hyperactivity disorder, also known as ADHD. 5. Isaiah Chance's decision-making was impaired by his borderline intellectual disability and ADHD. 6. Isaiah Chance did not personally carry, display, use, threaten to use, or attempt to use a firearm during the commission of the offense. 7. Prior to this case, Isaiah Chance had never been arrested. 8. Isaiah Chance cherishes fatherhood and has a great relationship with his 3 children. 9. Isaiah Chance has a loving and very close relationship with his parents, siblings, grandmother, and godmother. 10. Isaiah Chance helped his grandfather and grandmother when his grandfather had cancer. 11. Isaiah Chance attended church with his stepfather and his grandmother. 12. Isaiah Chance helped his mother around the house. 13. Isaiah Chance was motivated and preparing for a career as a merchant seaman. 14. Isaiah Chance was described as a quiet, respectful, and nonviolent child by family members and friends. 15. Isaiah Chance has the continued support of many family members and friends. 16. Isaiah Chance is a son, brother, grandson, and father whose life has meaning to others. 17. Isaiah Chance is capable of growth, redemption, and maturity because of his young age. 18. The existence of any other factors in Isaiah Chance's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Mitigating circumstances as to defendant Sean Gathright. Number 1, Sean Gathright has no significant history of prior criminal activity. Number 2, Sean Gathright's age at the time of the offense. 3, Sean Gathright was 18 years old at the time of the offense. 4, Sean Gathright was raised in a military family with repeated parental deployments, resulting in frequent relocations and prolonged separations from both of his parents. 5, Sean Gathright was primarily raised by his paternal grandmother due to parental absence and instability throughout his life. 6, Sean Gathright lacked a stable male role model or consistent guidance during formative years while he was a teenager. 7, Sean Gathright was subjected to verbal abuse by his father. 8, Sean Gathright was subjected to physical abuse and injury at the hands of his biological father. 9, Sean Gathright lived in an environment marked by fear, conflict, and lack of safety in his father's home. 10, Sean Gathright struggled with identity formation and belonging in adolescence. 11, Sean Gathright experienced isolation and difficulty adjusting socially after relocation in adolescence. 12, Sean Gathright was highly susceptible to influence due to his age. 13, Sean Gathright's decision-making was influenced by peer groups and an unfamiliar culture. 14, Sean Gathright is described as kind, respectful, and nonviolent by family and friends who know him. 15, Sean Gathright is optimistic and a positive support for family and friends. 16, Sean Gathright loves his sister, nephews, mother, grandmothers, and friends. 17, Sean Gathright is loved deeply by the family who have supported him. 18, Sean Gathright has been described as calm, well-mannered, and non-confrontational. 19, Sean Gathright has the capacity to contribute positively to those around him. 20, Sean Gathright is a son, brother, grandson, and friend whose life has meaning to others. 21, Sean Gathright is capable of growth, redemption, and maturity because of his young age. 22, Sean Gathright has the desire and potential to mentor and positively influence others, particularly younger individuals in prison. 23, Sean Gathright fed the homeless and was very involved in community projects in Mississippi when he lived with his paternal grandmother. 24, Sean Gathright traveled to foreign countries on mission trips for humanitarian purposes. 25, Sean Gathright participated in educational international travel programs reflecting exposure to broader opportunities. 26, Sean Gathright demonstrated entrepreneurial initiative including running small businesses, pressure washing, detailing, and photography. 27, Sean Gathright showed motivation and productivity at a young age. 28, Sean Gathright has demonstrated the desire to be productive by taking courses in an incarcerative setting. 29, Sean Gathright engaged in creative and constructive outlets, including photography and media work. 30, Sean Gathright has shown resilience and adaptability despite adversity. 31, Sean Gathright can contribute significantly to the prison workforce. 32, the existence of any other factors in Sean Gathright's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Mitigating circumstances as to defendant Rashad Murphy. Number 1, Rashad Murphy has no significant history of prior criminal activity. Number 2, Rashad Murphy's age at the time of the offense. 3, Rashad Murphy was only 30 years old when the homicide occurred. 4, Rashad Murphy has a history of physical and emotional abuse as a child, consistent with childhood post-traumatic stress disorder. 5, Rashad Murphy has maintained a loving relationship with family and friends while incarcerated. 6, Rashad Murphy has developed religious and spiritual awareness while incarcerated. 7, Rashad Murphy helped raise his younger siblings, including working jobs at a young age to provide financial support. 8, Rashad Murphy loves his children and has been a good father to them. 9, Rashad Murphy, as a minor, was removed from his primary home and placed into foster care due to negligent and abuse situations in the primary home. 10, Rashad Murphy has no prior felony convictions. 11, Rashad Murphy has displayed appropriate behavior and the ability to follow rules while incarcerated. 12, the existence of any other factors in Rashad Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Mitigating circumstances as to defendant Davion Murphy. 1, the capacity of Davion Murphy to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. 2, the capital felony was committed while Davion Murphy was under the influence of extreme mental or emotional disturbance. 3, the age of Davion Murphy at the time of the offense. 4, Davion Murphy suffers from traumatic brain injury. 5, Davion Murphy was exposed to repeated violence in his childhood and young adult life. 6, Davion Murphy is in the borderline range of intellectual disability. 7, Davion Murphy grew up in a household marked by instability and financial strain. 8, Davion Murphy did not have a stable male role model in his life. 9, Davion Murphy's father was diagnosed with schizophrenia. 10, Davion Murphy's father was incarcerated for life when Davion Murphy was 12 years old. 11, Davion Murphy took on a parental role for his younger siblings. 12, Davion Murphy is loved by his family. 13, the existence of any other factors in Davion Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. The final step in the process is for the jury to determine whether a defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all of the following factors. 1, whether sufficient aggravating factors exist, and 2, whether the proven aggravating factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the result of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that a defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty for a defendant, the court must sentence that defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty for a defendant, your recommendation for that defendant must be for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight and deference to your recommendation. You will be provided forms to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that human life is at stake, and bring your best judgment to bear in reaching your decisions. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? And 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. Defendant Sean Gathright has become a witness in this case. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for the lawyers to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to the lawyers about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its aggravating factors against the defendants. It is not necessary for a defendant to disprove the aggravating factors. It is up to the state to prove the aggravating factors by evidence. Defendants Isaiah Chance, Rashad Murphy, and Davion Murphy each exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of any kind or be influenced in any way by this decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Criminal gang member applies only to defendants Isaiah Chance, Rashad Murphy, and Davion Murphy. Criminal gang means a formal or informal ongoing organization, association, or group that has as one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Criminal gang member is a person who meets 2 or more of the following criteria. 1, admits to criminal gang membership. 2, is identified as a criminal gang member by a parent or guardian. 3, is identified as a criminal gang member by a documented, reliable informant. 4, adopts the style of dress of a criminal gang. 5, adopts the use of a hand sign identified as used by a criminal gang. 6, has a tattoo identified as used by a criminal gang. 7, associates with one or more known criminal gang members. 8, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. 9, is identified as a criminal gang member by physical evidence. 10, has been observed in the company of one or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. It is the intent of the legislature to allow this criterion to be used to identify gang members who recruit and organize in jails, prisons, and other detention settings. 11, has authorized any communication indicating responsibility for the commission of any crime by the criminal gang. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 4, your duty is to determine whether the appropriate sentence in this case is life in prison without the possibility of parole or death. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. The verdicts must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and they are as follows. Defendant Isaiah Chance, jury verdict form, penalty phase. We, the jury, find as follows as to Isaiah Chance in this case. A, aggravating factors. 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. And you would check yes or no. 2, we, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance was a criminal gang member at the time of the homicide. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes as to any aggravating factor listed, proceed to Section B. Section B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. Check only 1. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole. We, the jury, find Isaiah Chance should be sentenced to life in prison without the possibility.
Sorry, you just forgot to say word that.
Oh, okay. let me back up. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole or death. And then you would check one of the following two. We, the jury, find Isaiah Chance should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank, and you would fill that in, that Isaiah Chance should be sentenced to death. Dated this blank day of May 2026 in Hillsborough County, Florida, and there's a line for the foreperson of the jury to sign and print their name. As to defendant Sean Gathright, jury verdict form, penalty phase, we, the jury, find as follows as to Sean Gathright in this case. A, aggravating factors. 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And then the definitions I've already read to you regarding cold, calculated, premeditated, and a pretense of moral or legal justification. Again, you would check yes or no. 2, we, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright created a great risk of death to many persons. And again, you would check yes or no. Number 3, we, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes to any aggravating factor listed, proceed to Section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. Again, check only one. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Sean Gathright should be sentenced to life in prison without the possibility of parole or death. And again, you check one of the two. We, the jury, find Sean Gathright should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank that Sean Gathright should be sentenced to death. Defendant Rashad Murphy. Verdict form, penalty phase. We, the jury, find as follows as to Rashad Murphy in this case. Aggravating factors. Number 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions are included there, and they are as I have instructed you previously. And you would check yes or no. 2, we, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy created a great risk of death to many persons. Again, check yes or no. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Again, check yes or no. 4, we, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was a criminal gang member at the time of the homicide. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes to any aggravating factor listed, proceed to Section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. And again, you would check only one. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Rashad Murphy should be sentenced to life in prison without the possibility of parole or death. And again, you check 1. Either we, the jury, find Rashad Murphy should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank that Rashad Murphy should be sentenced to death. Gave this blank day of May 26 in Hillsborough County, Florida. Again, lines for the foreperson to sign and print their name. Defendant Davion Murphy, verdict form penalty phase. We, the jury, find as follows as to Davion Murphy in this case. A, aggravating factors. 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the same definitions apply as I previously instructed you, and you would check yes or no. 2, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy created a great risk of death to many persons. Again, check yes or no. Number 3, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Again, check yes or no. 4, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was a criminal gang member at the time of the homicide. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes to any aggravating factor listed, proceed to Section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. And you'll only check 1. We, the jury, have unanimously found that the state proved 1 or more aggravating factors. Each of us has considered whether 1 or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Davion Murphy should be sentenced to life in prison without the possibility of parole or death. And again, you check 1 of these. We, the jury, find Davion Murphy should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank that Davion Murphy should be sentenced to death. Dated this blank day of May 26 in Hillsborough County, Florida. Again, signature and lines for the foreperson to sign and print their name. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson, and you keep the same foreperson if you decide, who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when your deliberations are concluded and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you have reached a verdict. You must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items are received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Okay, so does anyone have any electronic devices in the, okay, so you guys kind of know the drill. Juror 168, Mr. M.N., do you have anything in the jury room that you need to get out? Okay, so this is the same as last time, right? So you guys we're going to go into the jury room. Do not begin discussing anything about this case until our alternate has left and until the bailiffs have left. You will receive all of the evidence that was submitted, and you will also receive, the bailiffs will bring in the actual final verdict form. Each of you, again, were given a copy for your own use, but the official verdict form will be the stapled copies that the bailiff brings in, and that's what you all are to utilize. Okay, very good. So I'll talk to our alternate after you grab your items. If you have any electronic devices on you now, anything, leave them in your chair. Otherwise, the bailiff will collect them and bring them out here.
All right.
Okay. I just want to thank the attorneys for the state, Mr. Harmon, Ms. Ismer, Ms. Doherty, Mr. Hernandez, Mr. Gonzalez, Ms. Finkelstein, Mr. Sonardes, the various Sonardes, Mr. Petrides, Mr. Bolt. You all are just the height of professionalism and ethics, and it really is a pleasure to have you in my courtroom. I never, ever have to worry that any of you are going to violate the rules or treat each other disrespectfully or treat me disrespectfully, and it really just makes my job simpler. So I do appreciate it. So I just want to commend you all for that. Thank you. Okay, so I don't even really have the words to thank you for your service. It's such a hard thing in these cases, particularly cases of this magnitude that take this long, and we have alternates, and you have to sit and listen to all the evidence, and then we tell you, surprise, you don't actually get to partake in the decision. But I do hope you realize how critically fundamental you are to the process. As we discussed before, in these cases, we have to have 12 people decide these verdicts. And if something happened and we didn't have an alternate, we'd have to start all over. And you now very well are very familiar with all that goes into these cases. So I just want to thank you on behalf of everyone, on behalf of the citizens of Hillsborough County. Thank you so much for your service. And the good news is you are now released from your jury service. You're free to talk to whoever you would like to about the case. You're free to stick around. You're free to go. And again, just thank you so very much. Thank you. Okay, so we'll be in recess pending a verdict.
All right, we're going to go with 11:35 starting. Jury starts to deliberate at 11:35 a.m. Eastern. It'll just be easier to remember. All right. 11:35. We'll just say it starts 11:35. Is their start. All right. And we can get a picture of Julio there. me see here. Where's the clock? All right. All right, so let's go through some things that happened today. While we wait, we do have a poll. Let's see, how long do you think the jury is going to deliberate? Where's my poll? Let's see what we got so far. So we got 0 to 1 hour, 7%, 1 to 2 hours, 22%, 2 to 3 hours, 36%, and 3+ hours, 35%. So it's 11:35, 12:35, 1:35, 2:35, 3:35. Yeah, I think it's pretty strong that they're going to come back and deliberate. I'm sorry, going to come back with a verdict. Interestingly enough, for the guilt phase, they started at 10:30, 10:25. So it's pretty much about the same, an hour difference. But and they took until 6 o'clock for Mr. 6 there. That's when they came back, was at 6, which was pretty interesting. It'll be really funny if they deliberate for 6 hours this go around. Again, if you believe in numbers and signs and all that stuff. All right. Yeah, if you guys have questions for Sam, you guys can certainly ask them now. Hawking, lunch usually comes around 12:30, so they are probably going to have lunch soon. I would say within the next half hour to an hour. So, yeah, if you guys have questions for Florida PI Sam, I will be her guest tomorrow at 7:15. And is it exclamation point Sam? Is it working?
The bot's not working.
Okay.
Nothing's working. You have to do it manually.
Got to do it manually. Okay. AWOL says, let me make sure I can see these chats. All right. AWOL says, Squeegee and Aaron, great work from the pretrial history to coverage, etc. I watched a lot of trials and I never seen this level of homework. Props to you both. Thank you. Thank you, AWOL. And props to Florida PI Sam for, just making sure that we were accurate, in our helping guide us to resources on the internet, videos, all that stuff. So thank you. Thank you for that, AWOL, and thank you to Sam. Kitty Cam. Well, we have pizza coming. Molly, we already ordered pizza. We ordered pizza the night before. we have our connections direct line. We have his text, his phone number. So we text him the night before. That's how dedicated we are to our pizza. Let's see. Oh, here. Yes, here. So tomorrow night at 7:30 p.m. Eastern, I'm going to be joining Florida PI Sam on her channel. 12-hour kitty cam. We might. Well, I don't know. We might get to some kitty cam. I don't know. It's going to be tough. I don't want to be in the middle of kitty cam and then a verdict comes in. So we may hold kitty cam off. We may hold kitty cam off for a little bit. All right. Let's see here. Thank you, Joanne. Appreciate that. Scott says they all look scared today. I don't blame them. Yeah, I know. It is Pizza Friday. Debbie said 2 to 3 hours. Hellrider, what is the next trial? Okay, so that's for Sam. Let's see. I don't know. Can she say that? I guess. Well, we'll ask her. I'll ask her. All we can do is ask her. Hold on a sec. Let me make sure I get your questions, get your answers. I should say, get your questions. All right, let me get Hellrider. Where'd it go? There it is. All right, what's the next trial? All right, what else? Do you guys have others? Camilla, I got yours. Do defense attorneys. YT Hazel, my comments never get seen. Kind of sad. I rave, but that's okay. Big chat, I am okay. What do you mean your comments don't get seen? We're seeing them. 7:15 tomorrow sounds good. Thank you, C. Gilmore. I'm not sure which idea I had that you think is great, but I'll take it. I'll take the compliment. Joanne, you never know. You know you've made it when you have a direct line to pizza. Exactly. Camilla says, can't wait for this channel pre-trial prep for Tupac. Me too. Yeah, I'm looking forward to that. That's August is going to be a crazy, crazy month for us. August is going to be a crazy month. Crazy month. So, Elaine, Chris and Aaron, thank you for the amazing coverage of the trial. I was well hooked. Your stream is next to none. Fingers crossed and grows in support. Thank you for that. Appreciate that. Joy, how do you think you would feel if you knew your life was on the line? We can ask that. We can ask that tomorrow. I know I would be, you know what, bricks. But, sometimes it is what it is. K-Dude, judge said she does not have to rely on the verdict, but gives it heavy weight. No, the judge can go down. She can't go up. So if they do life without parole, she cannot go up to DP. If they do DP, she can go down. She can go down. No problem, Hellrider. She can go down. She can go down. Ronnie V, all you mods are doing a great job. Thank you for that. Pizza ordering. Oh, good idea. Gotcha. Thank you. Yeah, I needed context because there's like a 20-second delay. So when I'm talking and then you guys hear me and then you post a chat, it's like 30 seconds or a minute has not gone on and I'm already on to the next 20 subjects. So give me context. Give me context. Thank you, C. Gilmore. Appreciate that. Lori, what kind of pizza do you like? I just go with straight up cheese. If I could get it, I would do roasted red peppers. I love roasted red peppers on my pizza. Aaron gets pepperoni, so we do half and half. Half pepper. I like onions on my pizza too, but roasted red peppers if I can get it. But normally just regular, just cheese. Camilla says, you know nothing about Tupac, just that he was great. You were a teen in Brazil at the time. Joy, wondering how do you think? Oh, you're asking me that, so that's not a question for not a question for Sam. How do we feel if like I said, I'd be probably pretty scared. I think I'd be pretty scared. I would, but that being said, it's like if you did something, and in your mind, if you did it and you thought that what you did was right, then you would probably be okay. You'd be, hey, I did what I did. This is, if you think that what you did was correct and you were found guilty for it, you would probably say, well, I did what I did, so you would I would think you would come to grips with it, Angelo, cats bring you allergies just looking at them. We have a lot of them. We have 7. Scotty Max says that judge has sentenced the DP twice. That I don't know. Living Ghost needs some olives, some kind of meat. Sherry, yes, the mods are working overtime because Vox 4 is not working right now. Joe for Vermont, yes, the pineapple is always. His name is Keith D. My head is so not there yet, so I got to keep looking at the reminder. Keith D is his name is Dwayne Keith Davis. Dwayne Keith Davis. Keith D. He goes by Keith D. All right, is this a question for Sam? I understand the why, the 8 to 12, but shouldn't it be unanimous? Seems the legislation, state Supreme Court will need to look at this since DP without unanimity. You got me there, wizard. Could be unconstitutional. Well, as we know, it was changed after the Nicholas Cruz Parkland shootings that they decided to change it because it was not unanimous, and of course, all the families got extremely upset. I forget what was the finding. What did they finally come back with? Do you guys remember, or if you know, let me look it up. What did the jury come back with in Nick Cruz? They recommended life. It was 11-1. So there was one person that was holding out. So they changed it after that. So it was 11-1, and they changed it after that. It's one person, so they changed it after that. Everybody wants pizza. Give me all the toppings since you can't have cheese. Red pepper flakes, yeah. I like a little red pepper flakes too. Cherry veggie pizza is your favorite. All right. Stanford Truth says, not to minimize the fact that they did what they did and probably callously, I still think they should get life without parole. Well, his history is deep. His family members were with Black Panthers, and his aunt Shakur as well. Still on FBI top 10 most wanted. Google it. Crazy story. Yeah, we're gonna get into that. We'll get into all of that. We have a busy August. We have a busy August. Eva Renee says, don't recall defense ever claiming innocence. They question certain evidence as they should. No. I mean, certainly after they were convicted. No. Well, none of the defendants they never argued that they were there. Everybody said, hey, we were there. We were in Tampa. They all agreed to that. And then it was in the guilt phase, it was, well, can you prove that they were at the hotel? Can you prove that they were in those cars? So they kind of hung their hats on that. And then after that, now it's, what happened is terrible, but they still have value to society and they can still give back to society, even though they will be in prison for the rest of their lives. I think actually every single attorney said they're going to die in prison, one way or the other, either by the hand of the government or natural causes. So they are, and nobody questioned that. All right, here, hold on. Let me make sure I get this, Wizard of Ezzy. So this is for, if there was a stealth juror, there is a jury that is in jury selection where the change should be not in the recommendation, unanimous vote. Chair of the colleagues and brains were blown. Okay, we will ask her that. Eva, what's the next trial? Carlos Dominguez, we're pretty confident that that's going to be streamed. There have been media requests from multiple channels, multiple media outlets. So Carlos is going to start 2 weeks from now, 25th, right? 26th. Yeah, so the next big one for us is going to be Carlos. Carlos Dominguez 2.0. We covered his first trial. It's a fascinating trial. He stabbed 2 people and they passed away, and he stabbed a 3rd person and she survived. Fascinating trial. Jury found him not guilty on those 2 counts that people passed away. Were hung on the one where the woman survived. Schizophrenia. All kinds of stuff. So it's very fascinating. It's out of California, University of California, Davis. So UC Davis. Definitely going to be a very interesting trial. And we covered it the first go around. We're going to do a huge deep dive all next week. We do have an ego. Yep, we got Ego Takes the Stand on Monday. I'm not going to say what it is yet. I'm going to keep you guys in suspense. But we're going to do an Ego Takes the Stand on Monday. We're going to do Paul Canero on Tuesday, and we're going to stay in New Jersey and do Sean Higgins. He's had a couple hearings, so we'll do Sean Higgins. So Monday is Ego Takes the Stand. Tuesday is Jersey. And then we're going to start our deep dive on Carlos. So definitely is going to be a good one. If you guys did not watch the first one, we have it as a playlist. But we will be deep diving Wednesday, Thursday, and Friday, and then following Monday too. And I'm gonna reach out to some guests, and we're gonna try and get some guests on during the day that we can we can talk to them about this. So definitely will be fun. Definitely will be fun. Wizard, you thinking of pizza? You're going to make fried egg Sammy with breakfast sausage. Nice. Yum, yum. Why are you not green anymore? Well, you're red, actually. You're actually red. Shout out to Jersey. Yep, it's going to be a Jersey day. It's going to be a Jersey day on Tuesday. Johnny Tech says, hope they get a chance to live. Either way, they're going to be alive for about, don't get off my keyboard. You get off my keyboard, kiddo. Average on the row, no other way to say it, average in Florida is 22.8 years. It's like 23 years, basically. So you have appeals, obviously. You have years and years of appeals, so they will live at least 20 more years. So Rashad's, 32? He's going to be in his 50s. Davion, I think, is 29 now, 28, 29. 20 years, he'll be close to 50. Even Sean, who's just now 20, and Isaiah's 23. They're going to be 40 and 43. So they'll have a chance to at least have their kids grow up, watch their kids. So it's not like tomorrow they're going to they're going to get deleted. So they still have like 20 years. Then after today's not the end of it either. Then there's going to be like another period where the judge actually gives them the sentence. And we saw that with Jose Soto. Let me see what. Huh? Well, with Jose Soto, where there was a couple different, and then there's Alicia. There's still Alicia that has to. But they called it, I'm forgetting what they call it right now. Let me find Jose Soto real quick. Let's see, going through my notes here. Sorry for the noise. Okay, so a Spencer hearing. So they have to have a Spencer hearing still. So Jose Soto was found guilty on September 23rd. Then he was found, that was a guilt phase. Then the penalty phase was the 25th. Then they had a Spencer hearing on the 6th, and then the decision was that was October 6th, and then this decision was finally October 6th. So his trial was September 23rd for the guilt phase. Then the penalty phase was September 25th. So they went one right after another. Then they had a Spencer hearing about 2 weeks later. And then the decision was a couple days after that. So even, after today, they're still not going to, so what's today, May 15th or so, May 15th? So she's going to have a Spencer hearing, which is, I think that's a chance for people to come in and give impact statements. So we're not at the end of this at all. Let me see. So Spencer hearing in Florida is a special court procedure in DP cases where the defense and the prosecution present final evidence to a judge before a sentence is imposed. Originating in 1993 Supreme Court ruling, Spencer v. Florida, it gives the defense one last chance to argue for mitigating factors and provides the defendant the right to make a personal statement. So today's not the end of it. Today's not the end of it. So there's still Miss Bree, you had pizza for dinner last night. So today's not the end of it. So whatever the jury comes back with, they still have to go through the Spencer hearing, which will probably be 2 or 3 weeks from now. And then the judge gives a final decision. So we're going to hear more impact statements. Maybe Sandrika Mays will get up. She did that's Charles's mother. She wrote a letter that was read in. She did not take the stand or talk. She didn't talk to the court, but she wrote a letter. And she was the only one on Charles's side, which is interesting. He didn't have any other family or friends. But maybe during the Spencer hearing, maybe that's when maybe more people will talk to him or talk on his behalf. So so today's not the end. There's going to be probably next 2 or 3 weeks from now. There's going to be another another hearing, another chance for both sides to say what they have to say. It's usually pretty short. I remember it was not long. It was like a couple hours maybe. Victim impact statements, all that stuff. So, all right. Eva's saying you don't have any chance with this judge, just formalities. Well, it is what it is, you know. Okay, Judge Cisco. Hillsborough County. Let me see how many. Nope. I want to see how many DPs she's been on. She's presided over numerous high-profile criminal cases, including multiple DP cases. She's a veteran judge who previously prosecuted capital murder cases and was noted for presiding over the 2020 sentencing of Granville Ritchie. So Granville Ritchie, 2014, 9-year-old girl, did some unspeakable things to a 9-year-old girl. So Granville Ritchie in 2020, she presided over that one. Let's see what else. She's handled other, of course, Alicia she's doing, and now, of course, this one. Let's see. Trying to think if I can find anything else. I do not remember Granville Ritchie. If you guys remember Granville Ritchie, I do not. Michelle Cisco. She was appointed by Governor Bush in 2002. She was elected 2004, 2008, 2014, 2020, 2006. Looks like 6 years. So she can be on the bench for 6 years, it seems like, as an elected. She graduated from Plant High School, Vanderbilt University, and the University of Florida College of Law, so that's UF. She graduated from law school in 1991. She became an assistant state attorney in Hillsborough, so it sounds like she's been in Tampa pretty much for her whole life. She prosecuted thousands of cases, including capital, and became the deputy chief of a felony division. She left in 1998. She left the state's attorney's office in 1998 to become associate with the law firm of Trombley and Haynes, which specializes in white-collar criminal defense work. Yeah. Criminal defense, yeah. So she went for the white-collar criminal defense. So she went for the corporate defense. Interesting. So she has been a defense lawyer. She has been on that side. She was appointed by Bush, Governor Jeb Bush, in August of 2022. She presides over criminal, civil, family, DV, juvenile, yada, yada, yada. What else? She is she's a parishioner in a Catholic church. She's a Junior League Community Advisory Board. She was Kappa Delta House Corporate. She was the president of the Delta Eta chapter. She's part of the Beach Club Women's Club. She's president, or she was. She was recipient in 2018. She got the Florida Bar's Judge of the Year Award in 2018. So doesn't say. Let's see. That's just her bio there. So I guess the other big one was this Granville Ritchie, and then of course now these Alicia and the four here. Yeah, let's see. May 22nd is Alicia, right? Was the 22nd next Friday? Yeah. So next Friday. So Ronnie, yes, that is correct. It was pushed down the road till next Friday. Right, today's the 15th. So next Friday. So that is definitely something we will cover. We'll keep that in mind. Let's see. Zorro sat here waiting for the verdict. Get yourself a drink. Sounds good. Lori, have any of the four had any disciplinary problems while waiting for this trial other than Sean? Well, Davion is in the box, and when you're in the box, that means you did something to put yourself there. So, yeah, Davion has been in the box. We're not sure what he did, but he has. They said that he has been in the box. That's what was brought in. I forget who brought that in, but it has been brought in. I'm not sure if the state brought that in. Maybe I'm not sure who brought that in. All right. Let me go through some of what we heard today. Then I'll play some previous. We can play some previous testimony. So today was all about the defense. Yesterday was all about the state. Today is all about the defense. We heard Jenna Finkelstein. She represents Sean. She spoke for 19 minutes and 15 seconds. She says Sean was a kid with no motive, history, but he got wrapped up in a culture he has no business in. He has, and always will have value. He's worth saving even in prison. Someone with so much promise made a catastrophic decision that will affect the rest of his life. Sean wanted to testify, and he wanted to take accountability. He said people ask God to do... Oh, thank you, Houdini, for that. He said, while he was on the stand, he said, people ask God to do something for them, but he's asking God what he can do for God. She says he'll die in prison. So I think pretty much all of them said they're going to die in prison, whether by natural causes or by the hands of the government. A vote for life doesn't excuse criminal behavior or diminish the life of Charles Jones. But Sean is a son, he's a friend, he's a nephew, he's a grandson, he's a baby brother, he's an uncle who's worth saving. She showed pictures of Sean at that point in time. And she could have lingered. I mean, she didn't stay on those pictures long. She picked him up, put him down, picked him up, put him down, picked him up. So I thought it would have been more impactful if she left him for like 30 seconds, even a minute, like talk and say, he's a son, and then just leave it up there, do that dramatic pause. I thought that would have been more impactful. So let's see. Then Isaiah, Justin Petradis, 17 minutes, 32 seconds on behalf of Isaiah Chance. He wanted to be a merchant seaman. He loved his family. His mom was a Marine. He always said, I love you when he hung up with his dad. He has value. He showed up for his children just like he did for his grandparents. And 7 people testified for him in the penalty phase. Then Deborah Toomey spoke for 22 minutes and 56 seconds on behalf of Davion Murphy. And she also said he will die in prison. The question is when. The question is when, not just the question is when. Then she quotes Gandhi. I know a couple of you guys were saying that. Eye for an eye eventually leaves everyone blind. Throw him into the violent streets of Jacksonville, because she was talking about his upbringing. He took comfort for the father figure that he never had, so he found that in these gangs that he connected with. Nothing that this sentence will do. Nothing that a D sentence. Let's see. Davion has 13 mitigating factors, but she says, but it's not a numbers game. Life without parole removes him from society, so it's never going to be a threat to society. You can be tough on crime without the DP. She shows the verdict form, page 2, jury recommendations, and then she marks. I thought that was pretty good. She's the only one that did that. She actually showed the jury, this is where you need to go, and this is where you need to mark. I thought that was good from a literally showing the jury, this is what I want you to do, He's going to be punished enough, she says. All right. Then we heard from Daniel Hernandez on behalf of Rashad Murphy. He spoke the longest. He spoke 32 minutes, 20 seconds. So he spoke the longest. Not all first degree warrants the DP. See, did you catch that rhyme? Not all first degree warrants the DP. Who is Rashad Murphy? And then he goes on, he talks about, you heard from Charmaine Steiger, who is his aunt, and they have 4 kids together. You heard from his aunt, you heard from his uncle. He got his GED while in jail, has various religious certificates of different religions too. I thought that was interesting. So it's not just Christian. I'm guessing he goes, I guess he's, or maybe it is sex within religious Christianity. I'm not sure. Anyway, he said that he has multiple religious certificates. He helps others with their Bible studies. All defendants are not the same. He continued to be a loving and supporting father. And then at the end, he said, please let him carry on as daddy to his kids. So I thought that was, that was a, going for the sympathy card. Whether it works or not, we'll see. Then Judge Sisko read the jury instructions. Must determine if aggravating factors are proven beyond reasonable doubt. That increases the gravity of the crime. You can only look at what the state has proven. And then she goes through Isaiah's was CCP, which is cold, calculated, and premeditated, criminal gang member. And then Rashad and Davion are contemporaneously convicted of a felony, great risk of deletion to many persons, the cold, calculating, premeditated manner, and then criminal gang member. So contemporaneous, that was basically, I think Sippen, we were kind of talking about that. That basically is that the incident. It's the actual, taking out of Charles and then Xavier, Gino, and Camilla being injured. So that's the contemporaneously convicted. So what the jury did, they bring that into now this penalty phase. I don't remember her going over Sean. That's the thing. She skipped to at least aggravating factors must be found. At least one aggravating factor must be found. I don't remember her talking about Sean. So I don't know what that was about. So you must be unanimous in finding the aggravating factor. That's what's interesting. That's interesting to me. So it's not like you just go in there and 8 out of 12 say DP and we're done. No, you have to go through. You have to determine if these aggravating factors were proven, and that has to be unanimous. Then from there, you can choose life without parole or the DP. So it's a multi-step process. You just don't go in there and say, I'm voting DP, right? And you could very well say that, but you have to then look at the aggravating factors, go through that first, and that has to be unanimous, apparently. At least one aggravating factor must be found, and you must be unanimous in finding that aggravating factor. Then you must also consider the mitigating circumstances. And she went through, Isaiah has 18 mitigating circumstances, Sean had 30, Rashad had 12 mitigating circumstances, and Davion had 13. Then she goes over the value of witness testimony, the verdict form. She goes through the verdict form. A, the aggravating factors, and then B, recommendation needs to be 8 or more for the DP. So, yeah, that's what I was thinking. She said multiple religions, so I took it as not just, Baptist, Catholic, Protestant. I took it as, Hindu, Muslim, that's what I was, Judaism. I don't know. But I took it as that, not just within Christianity, but, stand for the truth. I did a little bit of research on Julio, and while no one deserves something like this guy was a real instigator, and I'm not meaning that to justify it in any way. Yeah, I mean, I think by all accounts, he led the life, take that for what it is. He led the life, and he wore his life on his sleeve, Let's put it that way. He didn't hide from his life. He didn't hide from it. He rapped about it. He talked about it. He sang about it. He lived his life. And that life is caught up to him. Life caught up to him. And we are here, that's why I'm thinking like there might be something on some level where, you take out somebody that you hate so much that you're like, hey, you know what? I got caught. I'm going to face the DP myself. Is life so bad? Because back where I'm from, I'm a hero. That's why maybe it's, maybe it's not that bad of a thing, if you will. You know what I'm saying? Miss Bam says, that's the only good thing about you being a felon. You will always get out of jury duty. Nice. Michael, you do not have to choose all the aggravating factors, just one. That is correct. Yep, they just have to, just one. And they all have like 4 or 5. Oh, wait, no, I'm sorry. Isaiah had CCP, criminal gang member. Yeah, they have like 4 or 5. Well, I'm sorry, 3, 2, 3, yeah. So. Wizard of Ezi thought of it as theology. True. Stand for the truth. That is true. Julio seems to dance on the graves of those he didn't like. That I would, from his videos and his songs, I would not argue that. But all that being said, he didn't deserve to be shot. Nobody does. Brat, one of the defendants had mitigators for offensive age at offense and separately age at 18 at offense, which seemed odd to me. That would be Sean was 18, and I think Isaiah he was 23 now, so he was 21. So I think for both Sean and Isaiah, they brought those in. So that is correct. Davion, Rashad's the oldest, and then Davion. Rashad, I think, is 32 now. Let me see. I think Rashad's 32. Yeah, Rashad's 32. He was born in 94, and then Davion's born in 97. So he's 29. So, yeah, Alicia and Isaiah are both 23. And then Sean is 20. So he was 18 at the time. So, JMS, I find it pretty striking that they are now asking for compassion when they showed zero compassion for Julio Foolio on his birthday, no less. Well, you got to do what you got to do, right? CC123 Leo, good afternoon, chat. Happy Friday to you. Bama Green Eyes, I wonder what Alicia Andrews is thinking. What is she feeling? Yeah. Well, she's going to find out next Friday. She's going to find out next Friday. She's going to her motion or her hearing for a new trial is coming up. Let's see. All right, hold on a sec. I've got to get this. Hold on a sec. All right. Christy, how many mitigating circumstances need to be met? I don't think any. I think it's all about the aggravating factors. They only need to meet one. I know there's something like the weight of the mitigating versus the weight of the, but they also said it's not a numbers game. I think they only need one. They could meet all mitigating circumstances and just meet one aggravating factor. I think that's all that counts. I remember they kept saying it's not a numbers game. It's not a numbers game. Texas Cat, exactly. He wasn't an angel, but didn't deserve to leave this earth. How many trials have we watched? And well, the one for sure that jumps out to me was Jodi Arias and Travis Alexander. It seems kind of like by a lot of accounts, Travis Alexander wasn't, may not have been the best person, if you will. He might have, arrogant, and he may have even treated Jodi poorly. I don't know. That's just her. But he didn't deserve to be taken out 3 different ways. You know what I'm saying? So it's like there's a lot of people that are like, they may not be the best people in the world, but they certainly don't deserve their ending at the hands of somebody else, Like I always think about Travis. When I was watching that, I'm like, Travis probably wasn't, it's probably kind of a jerk, But again, that's just from the testimony and my own personal observations. But Jodi certainly did not have the right to kill him 3 ways. Ambi, yeah, we definitely watched that. Aaron and I were watching Jodi. Black Man's Black. We're gonna do the Mo 3. At this point, no, I'm not familiar with that case. So I'll have to do some more research on that. So right now we have Carlos Dominguez. And then coming up in August, like I said, it's really busy. We've got Tupac, the Keith D one. We've got Shanna Gardner and Mario. We got that one. That's in August. And Courtney Clenny is in August going into September. So we'll have to keep our eyes out for that. I'll do some research on that. We'll do some research on that and see what that's about. Let me see, because I don't know anything about that right now because we've been so involved with other things. Let me see. All right. Delayed indefinitely. No new date officially scheduled. So that's Melvin Noble. Okay, that's out of Dallas. All right. He was ambushed and fatally shot in broad daylight. Wow, in I-35 in November 2020. Yeah, I have no idea. I totally missed this. So Yellow Beezy is the alleged mastermind. And Keywan White is accused of carrying it out. So it's Keywan White is currently serving a 105-month federal sentence for unrelated conviction. All right, so it looks like it's been postponed indefinitely. So that looks pretty interesting. And right now it's been postponed. So postponed indefinitely, I should say. So we'll keep our eyes out for that. We'll keep our eyes out for that one. Molly, how long have we been around? We just passed 2 years. We just literally passed 2 years in May. May 1st was right now, 2 years. We started with Karen Reed, like the very last 4 days of Karen. Actually, no, I'm sorry. We started with Charles Chud Daybell. We started with Daybell and did 4 days of him. And then and Karen Reed was like the last 4 or 5 days of Karen Reed. And yeah, no, thanks for that. Was not on my radar, so I'll definitely keep an eye out. Keefe, we do that Keefe. Appreciate that. Thanks for the education. Always looking to learn. Scott, do you think Alicia Andrews will result as the first one did? Well, she has to get to that point. She has to get to that point of actually having a trial. I think she's got some legitimate Yeah, I think she has some legitimate appellate issues there, to be quite honest. Tammy, you ventured over from RA. Awesome. Molly, well, happy birthday. Thank you. Appreciate that. Kimbers, yes. Woohoo, 2 years. Absolutely. Is today Don Julio Day? Is it really, CC? Don Julio Day. Is it today? No, not day of the... No. Don Julio Day. Okay, that's just a bottle. Don Julio Day. I can't find it. Can't find that, but all right, we'll take it. We'll take it on value. Elaine, thank you. Happy birthday to Trial TV Live. Appreciate that. Let's see. Oh, did I misunderstand what Tammy was saying? Are you saying right now or are you saying before? I don't understand. Oh, you got me. You got me then. That's funny. Because my mad Google skills did not corroborate that. CC123. Leo BBCC. That's a good one. All right. Tammy, you've been here all morning, just working and lurking. Right on. Happy belated 2-year anniversary. Thank you. See, Gilmore, you celebrate Don Julio with some Santos. Yeah, G1Z. CC got me. That's the way I interpret it too, Tammy. That's what I thought. You found us through RA. Okay, that's what I thought as well. That's how I interpreted it. So good, I'm glad I interpreted it. All right, Sherry. Have a good one. Positive vibes. Happy 2 years to Trial TV. Thank you, thank you. All right, let's see. I'm going to play some previous testimony. What do you guys want to hear? What do you want to hear? You want to hear from Sean again? Sean was only like 30 minutes. He really wasn't that long. What do you guys want to... is there anything you want to hear? Oh, good. Good, Tammy. Because that's how I took it. P. Cooper, we found you from RA. Awesome. Yeah, Scott's been a huge supporter of our channel. And going to go have some pepperoni pizza for dinner. JMS. Sounds good. The Pretty Chick, happy 2 years. Glad I found this channel. Y'all are really nice people. Thank you. And thank you for helping our channel, our chat be kind and respectful. You guys want to hear Sean again? JMS? Sean? Okay, we'll do Sean again. Okay. Yes, please, Sean. All right. All right, let me find Sean. Chat has spoken. On to Sean we go. Why don't I have his... Wait a minute, hold on. Oh, it was in there. Oh, wait a minute. Hold on a sec. Oh, appreciate that. Thank you, G1Z. Just chipping in on some cat food. Appreciate that. JMS just stumbled upon your channel last year. I'm glad we did. Thank you. Hellrider, cool. Happy 2 years. Hut 95, I found this channel during this trial, the only channel that has good audio. Appreciate that. We do our best, man. We do our best, and we try to make it a good experience for you all. Why can't I find Sean? When the heck did he testify? When the heck did Sean testify? It was during... I don't have it in my notes. Why don't I have it in my notes? Oh, was it impact statements? Maybe it was impact statements. Where the heck is Sean? Oh, defense. Wait a minute. Why don't I have my notes on when he testified? Okay, that's really weird. It must have been after. It must have been after. It's when it was allocution, right? It was allocution. When the heck did he testify? We didn't testify. It was his allocution. May 12th, Kimbers, 2 days ago, May 12th. Oh, well, it would help if I was looking at the right notes here. Yeah, it would help if I was looking at my right notes. I was looking at Jose Soto. Yes, day 2. He was the last one. Day 2. All right, day 2. That is when day 2. 2 days ago, May 11th. Actually, 4 days ago. It was day 2. All right, day 2. It would help if I had my notes right. I was looking at the right notes. All right. Not that one. Not that one. It's got to be this one. There he is. I gotcha. Sean. All right. Let's check out Mr. Gathright here.
Hard losing a child.
All right. Let me get him queued up here. All right, so what we will do here, we'll put the live feed down here, live feed down there, and this is the feed up here. All right, so this is Sean. So this was from penalty phase day 2. Penalty phase day 2.
Very good. Let's go ahead then and bring in the jury.
Mama C, Carlos, jury selection starts on Monday. Well, they're going to go through the process of jury selection, but he's not scheduled to start until the following week. Opening statements will be the following week. So next week we're going to be doing deep dives on Carlos. So we're going to revisit Carlos, and we're going to get our heads wrapped around his trial again. So we'll be starting our deep diving of him, but he doesn't. Opening statements start the following week.
All rise.
Okay, very good. Everyone have a seat. All right, Ms. Finkelstein, your next witness is?
Gathright.
All right, Mr. Gathright, please stand up and raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay. Have a seat and you may continue.
Thank you, Your Honor. Please state your name for the record, sir, and spell your name for our court reporter.
My name's Sean Gathright, SeanGathright.
What's your date of birth, sir?
I was born on October 20th, 2005.
Mr. Gathright, you've heard people speak here today on your behalf and yesterday, and I know that you wanted to address the court and the jury. So I would like to ask you what you want the jury to know.
I just want to address the court today, and, I'm not here to dispute anything. I'm just here to be a man and take responsibility and express my feelings about this whole situation. That's what I plan on doing.
Okay. And how do you feel? What?
I feel very remorseful. This is a terrible situation. It's been a traumatic experience.
Let me ask you this. So, how old were you when you were arrested?
I was 18 years old.
We heard that you had started some college, obviously probably didn't get very far, right?
Right.
What have you done since you've been in jail? Is there programs? Are there things that you can do there?
So, I've gotten into programs. I've also, I grew up, in church and, in a Christian household. So I refocused my, life to Christ, and, I've taken a lot of religious programs. I've read the Bible from cover to cover. I've tried to, share some word, and, we have prayer circles in the jail and stuff like that. I've led a couple, prayer circles, and I've tried to, kids around my age or, younger, since I'm 20 years old now, when you turn 18, you go to the adult pods and stuff like that. So if I see somebody who I see, has a lot of potential and has a chance to keep them from, basically being able to be corrected at this opportunity and not come back, I try to take them under my wing. As you see, I have a lot of resources and a lot of family that love me, and they've even, asked me like, hey, is there anybody in there who doesn't have somebody like that, who, could we send them some money, like, anything like that. So I've tried to, be a vessel for God to pour over my blessings into those around me.
We heard from Mr. Bonosco, who said that, in prison that there is opportunities at times to be a mentor, or do orientations and peer-to-peer things like that. Is that something that you'd be interested in doing?
Of course, I definitely want to, try my absolute best to course correct anybody from falling down a path that they don't have to take, especially the youth. I feel like that's my calling that God has put on my heart to, be a mentor to the youth and be a positive influence in this world.
What about those relationships? Like you said, you have a lot of people. Are you able to maintain those relationships now?
Yes. So, everybody who I, maintain a relationship with wasn't able to all be here today or, even testify. But, I talk to them daily, weekly, bi-weekly. I cherish my supporters very deeply, and I want to maintain a relationship with them for the rest of my life.
And I know, we're not going to talk about the case itself, right? But you said that you were taking accountability, you felt remorseful. Tell us what you mean by that and what statement you want to make.
To the victim's family, I want to send my deepest condolences, and I understand that it's...
I just want to pause it here that he looks into the camera, right? When Ms. Finkelstein says, is there anything you want to say? He looks into the camera. Now, don't forget that Sean has photography, business, he's making videos. He's got a YouTube channel. But I just find it interesting that he looks into the camera So anyway, just noting that. So let me rewind that a little bit.
To the victim.
You said that you were taking accountability, you felt remorseful. Tell us what you mean by that and what statement you want to make.
To the victim's family, I want to send my deepest condolences and my, I understand that it's hard losing a child, a best friend, a brother, a cousin, and for that I just cannot say sorry enough. I feel terrible about the situation, but I'm a firm believer that God can use anything for good that the devil wanted for bad, and so I am grateful for the people I've met, for the lessons that I've learned, for just this experience in general, because it's one that I'll never forget, and it's going to shape the rest of my life.
Sounds like there's that saying, it's kind of cheesy, but you make lemons out of lemonade or whatever.
Lemonade out of lemons.
Somehow. I obviously don't make lemonade, but it sounds to me like you are going to try and make the best of a bad situation. Does that sound about right?
Of course.
And are you going to continue to do that?
Of course. I'm going to try to, continue a humble life, a righteous life, try to do the right things at all times, and,
Will you apprise yourself? We've heard about some, courses and programs and things that you can get involved with to stay busy in prison. Is that something that you plan to do?
Yeah, so hearing Raul's testimony was, the first glimpse that I have of, what prison could be like. I want to stay as busy as possible, stay away from bad apples. I want to, keep a job, get into programs, try to get into any vocational things I can do, try to, keep my record clean to, go to the best incentivized things and have visits with my family. And, I just want to just stay out the way, just want to make everything, peaceful as can be.
So even knowing that you're not getting out of prison, you want to make the best of your stay there?
Of course. I mean, who wouldn't? If you're going to be somewhere for the rest of your life, why would you make your life a living hell?
And you're young, right? You're 20?
Yes, ma'am.
Your Honor, may I have a moment?
Yes.
I'll pass the witness.
Okay, state.
You would agree with me that Charles Jones was young too, wasn't he?
Relatively young, yes, sir.
26, right?
Yes, sir.
That's what the evidence showed us, correct? You were sitting here watching that, correct? The evidence that came in over the last several weeks?
I was right there.
Yeah. And you want to take accountability now, correct? You want to take accountability now that this jury has found you guilty, correct?
Yes, sir.
Weeks after we went through a trial. Is that your testimony?
Objection, Your Honor.
I'm going to sustain the objection.
You indicated this was a traumatic experience. Is that right?
Yes, sir.
That's what you just testified to, correct?
That's what I said.
Let me just have one moment, Your Honor. I'm trying to get the all-know.
Yes.
Thank you, sir. You're welcome. Appreciate it. Stage 25C, you remember Gino Norris?
Yes, sir.
You remember him? He was also really young when this happened, wasn't he?
I didn't know how old he was.
Early 20s, 22. Would that surprise you?
No, it wouldn't surprise me.
Yeah. Gino Norris, who's not a gang member, who's Charles Jones' friend from the time they're children.
That's the legal basis.
The facts of the case that we were told.
Okay. Come on up, counsel.
26C, Xavier Edwards. 25C, Gino Norris. And you saw the autopsy photos of Charles Jones. My question to you is, after you and your friends inflicted that carnage on June 23rd, and as you were running, states 2059C, this is actually you running to shoot them, but when you were running back past that Tesla, were you feeling a lot of trauma at that point?
It was so long ago, I try to not remember anything from that night.
Were you remorseful as you were running back with that AR-15 in your hands?
Like I said, I try to remember nothing from that night.
Was it traumatic to you as you went back to the car with that AR-15? Was it still smoking? Was it still warm in your hands from firing it?
Sustain the objection.
Were you feeling remorse as you were getting back into the Impala?
Like I said, I just try to focus on today and moving forward.
So the next day, that Impala, that was your car. You drove that around, right? It was your mom's, but you drove that car, correct?
Yes, sir. It was my mother's car.
All right. And that was the car you drove from Jacksonville to Tampa in, correct?
I'm going to object beyond the scope.
I'm working to a point, Your Honor.
Okay, why don't we just get there?
All right. So this car, this Impala that you drove from Jacksonville to Tampa in with Mr. Chance and Miss Andrews, the one that you drove in tandem with the Silver Cruise, the same car that you utilized to drive the assault team, the shooting team, which you were a part of that night. That same car that you drove around Tampa in the early morning hours for several hours, tracking, stalking, and hunting Charles Jones and his entourage.
Sustain.
That same Impala, you drove that to Polk County the next day, and you dropped it at your grandmother's house, right? The same grandmother who came in here last night and testified for you, correct?
Overruled. Go ahead. You can answer that question.
Isn't that correct?
What is the question?
You dropped the Impala, the one that had all of these shooters in it, the one that was utilized in this murder, that was such a vital cog in this plan. You dropped it at your grandmother's house in Auburndale, didn't you?
I'm here to testify about today.
Are you going to answer that question, or are you going to avoid it? Because that's not what I asked what you were doing here today. I think we all understand what you're here to do today, what you're testifying about. I'm asking you specifically about your remorse. Were you remorseful when you dropped that car off and left it at your grandmother's house in Auburndale?
I did go to my grandmother's house.
Were you feeling remorse when you hugged her and got into the 4Runner and left her with the Impala after you wiped it down?
Sir, I'm just telling you that today I would like to express my remorse to the family and to the court.
I understand what you're trying to do today. I'm asking you, since you're trying to convince this jury that you're remorseful, were you feeling remorse that next day or later that day?
I don't remember these days in detail, how I was feeling, what I was thinking.
What about later that night when you went to Orlando? Were you feeling remorse when you were out partying at Club Parlay, celebrating what you had done that day?
That was my sister's birthday party.
What did you feel any remorse while you were drinking Don Julio tequila and putting that in your video and throwing gang signs?
I'm here to testify about today, sir. We've all seen the evidence. We've all reviewed everything.
Mr. Chance, it's not time for you now to make speeches. You've politely answered your counsel's questions. Can you not answer the state's questions? Is there something about my question you don't understand?
I was getting to
I'm sorry, Mr. Gathright. I called you Mr. Chance. Excuse me.
I was getting to my answer. Like I said, I've seen all the evidence.
Well, we've all seen all the evidence.
Yes,
right?
sir. That's true.
And after all that evidence came in, and this jury based their true verdict on that, convicting you, now you're taking accountability? Is that correct?
Sustain the objection. I think the question on the table was remorse about in Orlando. Okay?
It is, Your Honor.
You just need to answer that question. Okay.
So I'm going to ask you very specifically, okay? So try to focus with a laser beam here, Mr. Gathright. Were you feeling remorse when you were in Club Parlay in Orlando drinking Don Julio? Were you feeling remorse for what you did earlier that day?
I don't remember how I was feeling or what I was thinking.
Were you feeling remorse when you got pulled over in the Forerunner a couple of days later by the police?
I don't remember. I was nervous. I mean, I had never been involved in any police.
Were you feeling remorse when you were unloading the Impala and putting all of that evidence into the Forerunner? Did you feel remorse?
Sir, I told you I don't remember how I was feeling or what I was thinking in those days.
Mr. Gathright, you have led, you would agree with me, an extremely privileged life, haven't you?
Yes, sir.
You would agree with that, correct?
I would.
You've had a loving mother, correct?
Yes, sir.
A loving sister, correct?
Yes, sir.
You've had 2 wonderful grandmothers, correct?
Yes, sir.
You would agree with me, right?
I couldn't deny that.
One of which probably, I'm assuming, sacrificed and paid for you to go to that private school, that preparatory school, correct?
It wasn't paid. It was a magnet program, so I had to apply, and it was a lottery system.
It was a lottery system. Okay, so it was a magnet.
Yes, sir.
All right. She supported you going there, did she not?
Everybody did.
Gave you open use of her house, welcomed you, treated you, and parented you, basically, didn't she?
Yes, sir.
Took care of you when your parents were deployed, correct?
Yes, sir. At the time, I was living with my grandmother. Both of my parents had been either retired or out of the military. I was just living there more so. I needed a change of scenery, and my relationship with my father wasn't sustainable.
Okay. This is when you were in Oxford with your grandmother.
Yes, sir.
The nice lady we saw earlier came in here.
Yes, sir.
The one that has supported you and spoke so lovingly about you, correct?
Yes, sir.
And so you went to this preparatory school, and whether you got in there through a lottery or not, you would agree with me, not everybody gets to go to a school like that, correct?
The lottery school, the magnet school I went to was in middle school when I was living in Jacksonville. The school I went to in Oxford, it was just a public high school.
A public high school.
Yes,
okay, my mistake. So you went to that preparatory school in Jacksonville.
Yes, sir.
But again, that school was not something that every kid gets to go to, right?
No, sir.
Not every kid gets to have a counselor and a role model like Mr. Edwards, correct?
No, sir. I was very blessed.
And not many children get to fly in planes with their stepfather, correct?
No, sir.
And fly around in Asia and get to see islands off the coast of Okinawa, correct?
No, sir. I was very blessed.
You are very blessed, aren't you?
Yes, sir.
And not every kid gets to go to Scotland, right?
No, sir.
Or Ireland.
No, sir.
Or Paris.
No, sir.
Or London.
No, sir.
Or Spain.
No, sir.
Cape Town or Johannesburg? Or both in South Africa?
Cape Town.
Cape Town. Beautiful city, right?
Yeah.
You got to go experience that when you were growing up, correct?
I did.
Because you had such loving people around you supporting you, correct?
Yes, sir.
In fact, your grandmother went with you on that trip, did she not? Or not on that one, but on the ones to Europe,
trips,
correct?
yes, sir.
Yeah.
Yes, sir.
And we heard you got to meet up with your sister in one of those trips, correct?
I did. I had the privilege.
So you always had someone there taking care of you, and you always had good, strong male role models, including people at your grandmother's church and your stepfather, Mr. Harrington, correct?
I had male role models in my life growing up, but in my more formative years, more so 16 to 18, I did not have a relationship with my father, and the male role models that came and testified, they were present but not intimately as whenever I was younger, maybe middle school years. But when I turned around 16 to 18, it was the females that actually had that caregiving and nurturing relationship with me. But
thank you for clarifying that. I appreciate it.
Yes, sir. Towards the more recent years, I didn't have that one-on-one and very close relationship with you know, those male role models in my life. You know, you heard my stepfather say, you know, after the divorce.
I did hear that, Mr. Chance. Let me stop you,
Mr.
okay, and
Gathright.
we'll go back to my question. I'm sorry?
Mr. Gathright.
I'm sorry. I keep calling you that, Mr. Gathright. Let me go back to what you said earlier. Between 16 and 18, you didn't have a male role model? Is that what you're telling the jury?
I'm not saying I didn't have any male role models, but day to day, you know, young men need strong.
That's not what I
influence.
asked. I asked if you had a male role model between 16 and 18.
I had a figure that I could go to, but not intimately.
Mr. Edwards, right?
Yes, sir.
He had stayed in contact with you even when you graduated into high school, correct?
Yes, sir. We definitely maintained a relationship, but
And he
it
seemed
wasn't.
to be pretty enthusiastic about that, right?
Yes, sir.
In
Yes,
fact,
sir.
you went on a cruise with him at some point, did you not?
Yeah, when I was younger, yes. We had
Okay.
a very close relationship.
And then from what you're saying, if I understand it right, the females, I'm assuming you're talking about your grandmothers and your mom stepped into the gap?
Yes, sir. Yes, sir. It was grandmother's, mother's, sister.
So let me see if I got this right. When you were being brought up, and you were being brought up by a mother who was enlisted or an officer in the military, an officer, wasn't she?
I don't know exactly what her rank is. I know she was a sergeant.
But in the Marine Corps?
Yes, sir. She was in the Marine Corps.
All right. And then you had a stepfather who was in the Air Force, right?
Yeah, he was.
From the time you were 3 all the way up to when they divorced in 2020?
Yes, sir.
All right. They taught you right from wrong, correct?
Yes, sir.
And we
Of
heard
course.
that from your grandmother,
Yes, sir.
right?
Yes, sir. Yeah. Of course. Yes, sir.
Miss Lyle, she told us the same thing.
Right.
They brought you up in the church. They taught you about the 10 Commandments. They taught you about right from wrong. Did they not?
They did.
All right. And they were excellent role models about living your life in a disciplined, honest, and right way, correct? And being law-abiding, correct?
They really didn't have to worry about me. You know,
Well, let me just answer my question. Would you agree with what I'm telling you? That they were excellent role models of how to live a moral life?
Yes, sir. They definitely instilled the foundation.
May I have one moment, Your Honor?
Yes.
I have nothing else, Your Honor.
Okay, redirect.
Mr. Gathright, despite living, I think I did that. Despite having what you call a blessed upbringing, you still find yourself here today, right?
Unfortunately.
Where you had lived, we heard about Mississippi, and was Jacksonville different than where you had lived previously?
Jacksonville was unlike any other city that I've lived in or visited or any other country. The cultures, the neighborhoods, the people, it's completely different.
And how old were you when you kind of started experiencing that culture shock?
So when I moved to Jacksonville, I was about 9 or 10 years old. You know, I didn't really know much about what the streets were, quote unquote, the streets were. It was more whenever I got to high school and I wanted to leave the magnet school that I was at. I wanted to be at more of a neighborhood school to be around the people I grew up with, because at the magnet school it's 30, 45 minutes away. I, you know, didn't really know anybody. I wasn't as close as the people who I grew up with. So around high school, that's when I started hearing about, you know, and seeing, you know, the different things like, you know, the drugs and people dying and, you know, stuff like that. And then I was caught completely off guard, but I was curious, like, what is this, you know, and listening to the music, like, I was just, like, caught off guard. Like, I'd never experienced something like that, especially living in Japan and, you know, living in different states around the world. I mean, or in the country, it didn't have what Jacksonville had.
And we've heard from a lot of people that knew you, and I think it's been a pretty consistent theme that you were mature and, you know, smart and interested in things. But you were still, what, how old around that time?
I was 14, 15, you know. I definitely would consider myself to be smart and, you know, mature for my age, but
Still curious?
I was still a young boy, you know. I still am a young man.
You think you were kind of impressionable?
I would characterize myself as, you know, at times being naive, gullible, impressionable, and yeah.
And so despite that upbringing, are you finding yourself, you know, you're in a different culture now, but you still want to be as successful as you can?
Yeah, so being in the jail, you know, I'm by myself, especially in a city so far away. I don't know anybody, so I took this time to focus back in on myself and just get back to the basics.
All right, we have a verdict, you guys.
What I know, you know, and
verdict has
without
been
anybody
reached.
being in my ear or.
We have a verdict. We have a verdict. They're back. All right, we have a verdict out. All right, we have a verdict. I'm going to go ahead and stop the clock here. Stop the clock. So 1 hour, 22 minutes. So we got a verdict. 12:56. We'll say 12:55 just to make the math right. So, well, hour and 22 minutes or so. It's 11:30. Hour and 20 minutes. Yeah, well, hour and 20 minutes basically. All right. Was not expecting it that fast, but there we go. All right, I can end the poll. Can end the poll. All right. Now, the penalty phase, they gave them about a 15 minute to get back into court. All right, so how long will the jury take to deliberate? 7% of you said 0 to 1 hours. 23% said 1 to 2 hours. So that's where we fell. 34% said 2 to 3, and 36 said 3 plus. All right. Started at 11:30. Ended at 12:55. So an hour and 20 minutes or so. I will, yep. All right. So again, took them about 15 minutes or so to get back into the court once the verdict came in. So it still may be another few minutes. All right, hold on a sec. I'll be back in 2 seconds. All right. So again, for those that are joining, yes, a verdict has been reached. An hour and 22 minutes. We'll basically just say an hour and 20 minutes just to keep it easy to remember. Less than an hour and a half. It took them 7.5 hours to come back with a verdict of guilt, and now less than an hour and a half to come back with a verdict. Well, and we'll see. We'll see what they're going to come back with. But right now, we are waiting for lawyers and defendants to come into the courtroom. And should be another maybe 5 or 10 minutes or so. So we have, Kelsey, verdict, still waiting on it. Still waiting to hear what the verdict will be. Kathy Russin announced it from Law and Crime. So we saw it. We saw it posted, and she posted it. The guilt phase 2. She posted it there as well. So. You know what, CC? I don't think they're gonna need them. They're in cuffs, right? They're in what do you call it? Leg shackles. I'm pretty sure they're handcuffed as well. I don't. And there's really nobody there that wants to get like the gallery. You know, sometimes you have to protect the defendants from the gallery. I don't know. Well, we'll see. We'll see. I don't think they'll have any more than they normally have, but we'll see. She is not, but I texted, Horse Welfare, I just texted her. I said, verdict has been reached, and she's like, OMG. So she knows. Florida PI Sam knows. Okay, judge is coming back on the bench. Now we just need to get some audio. Oh, there you are. So she is. She came in. Kathy Russin, Wizard. Kathy Russin announced it on Law and Crime. Kathy Russin announced it on Law and Crime. So Florida PI Sam is with us. Woohoo! All right. Sam is in the house. Now let's just now we just need some audio. Sam is in a meeting in Ohio, keeping an eye on this. Debbie says, I still wish we knew what happened to Sean for him to give up his good life he had. Yeah. Barry Bratt prefers the blame the bot version of your comment. Fast verdict, oh bot. Verdict so soon, oh bot. Carolina says, will they all see each other in the system? They're going to be in the same. Yeah, there's only one row prison, one for male and one for female. So yeah, chances are they'll be in the same. They'll be in the same facility. And yes, please remember respect. That's true. No matter how you feel, just as a judge says, just be respectful. That's all. Just be respectful of each other. That's all we ask. Just be respectful. Stay positive. Good afternoon, everyone. I hope everyone is having a blessed day. Has anyone been sentenced yet? Just tune in. Been a busy. Well, you tuned in just in case, or I'm sorry, just at the right time. They are going to announce the verdict of the sentencing. So, Steph's, you didn't miss anything. They're just announced that there will be a verdict. Verdict has been reached. Camilla, this is a somber moment. I agree. This is a somber moment. So just keep that in mind. As much as whatever you guys feel, it's fine. Just be respectful. That's all. Just be respectful. Nosy Rosie, respectful is why I like this chat. Yeah, just that's all. Just be respectful. It's a somber moment. It's still, it's a very somber moment for everybody, for Miss Mays, for Julio's friends that are still around, for the 4 victims, or I'm sorry, the 4 defendants. Sorry, the 3 other victims. Let's not forget them. Gino, Xavier, and Camilla. It affects a lot of people. Elaine, yes, right back in time. Or we take out. It just came, actually. It came about 5 minutes ago. So, but obviously it can wait. Pretty chick, yes. Let's be respectful. That's all we ask. And if you need to vent, go somewhere else. Quite honestly, I'm over at Law and Crime, and it is brutal over there, you guys. So don't be Law and Crime. Let me just put it that way. Don't be Law and Crime. If you want to be Law and Crime, go over to Law and Crime. We don't do that here. Let's see. Athulus. I hope I'm pronouncing your name right. Much faster than what you anticipated. Vent the bad thoughts to yourself, or in your case, to your hubby. Right? Too precious. Very sad day for all. Agreed. Sherry, if they poll the jury, they just say yes or no. I'm not sure if they do or not. I'm not sure. And K-Girl, that's a good life motto, right? Am I tired at the end of the streaming days? It depends. Sometimes not. Hellrider, it is brutal, but it is real. Well, I see no respect going on, but I'm not here to talk about that. Let's not talk about that. Let's talk about other things. Let's see, Mama C, are we going to cover anything for the remainder of the day? To be determined. Yeah, we were kind of thinking about that. We may take a break for like an hour to eat, and then we'll come back. So, oh, and of course Sam. So tomorrow is going to be Florida PI Sam. I'm going to be a guest on her channel at 7:15. So definitely join us tomorrow. So we'll see. Whatever we do, it's going to be a little bit later. It'll be a little bit later today. Not much, but a little bit later. Stella, it's coming in. There's Scotty. Scotty Sonardi is in the house. Verdict's been reached. It's going to be read momentarily. I'm hoping a press conference, JMS. Yeah, I'm hoping we can get a press conference. I'm hoping we can maybe now there'll be a press conference. So yeah, we'll stay on until then. Erica, they are back. They are back. Gracie, yep, a verdict has been reached. We're just waiting for everybody to get settled in. Oh, come on, Super Ball. Don't right now.
Mr. Gonzalez, are we waiting for Mr. Hernandez or no?
Judge, he was not with us downstairs, so I'm not sure where he is.
Okay.
I'm sure he's close. If you don't mind, can I text him for 1 minute, Judge?
Sure.
The one deputy that's in the middle over there, he's gonna walk back with you with the evidence.
Which one?
He's in the middle there, Lugo. You know Lugo?
Oh, okay, yeah.
Mr. Wise,
Okay, go on.
Okay.
he's not, okay, yours, David.
Judge, Mr. Hernandez says that he would do about 10 minutes.
Okay. See,
He's at Starbucks, Judge, which is, I guess, on the corner.
Yeah. Okay.
4 blocks away. Okay.
All right. Okay.
Judge, the court can go on.
Yeah, okay, let's do that, just because everyone else is here.
Understood, Your Honor.
It's been a long 6 weeks, and I don't want to keep the jury waiting unnecessarily, so, okay. All right, very good. It's my understanding the jury has reached a verdict, correct?
Yes, ma'am.
Okay. Bring in.
Thank you, Judge.
So Rashad's Daniel Hernandez, the advocate for Rashad, is not there. So it's Rashad's advocate, Danny Hernandez, is not there. Not sure where he is, but he's not there. So Brian Gonzalez was guilt phase. Daniel Hernandez was penalty phase. So he's the one that spoke last for Rashad. He is not there.
I just need to remind everyone again, there's not to be any audible reaction after the jury's verdict is read, okay?
Ready, Judge?
Yeah.
All rise. All due ready, Judge.
Okay, very good. Everyone have a seat. And it's my understanding the jury has reached its verdict for the penalty phase, correct? All right, very good. You would hand the verdict form to Bill.
Yes, ma'am.
Madam Clerk, please publish the verdicts.
The same. Defendant Isaiah Chance, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification? Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole or death. We, the jury, finds Isaiah Chance should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026, in Hillsborough County, Florida, Miss C.S., foreperson of the jury. Defendant Sean Gathright, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more of the mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Sean Gathright should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Sean Gathright should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026, in Hillsborough County, Florida, C.S., foreperson of the jury. Defendant Rashad Murphy, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more of the aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Rashad Murphy should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Rashad Murphy should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026, in Hillsborough County, Florida, C.S., foreperson of the jury. Defendant Davion Murphy, jury verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more of the mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Davion Murphy should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Davion Murphy should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026, CS foreperson of the jury.
All right, members of the jury, now I'm going to ask you all the same questions similar to what happened after the guilt phase for the whole jury. So, I'm going to ask you about the jury's decisions that you have just heard. Juror number 9, initials DN. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 16, initials AM. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 19, initials LY. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 24, initials WW. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 32, initials CRP. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 47, initials AM. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 49, initials CG. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 78, initials AC. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 142, initials TL. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And Juror 157, initials CS. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And Juror 158, initials JH. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And Juror 167, initials JE. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? All right, I have one last formal instruction for you all, then I have something more personal to say. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. On a much more personal note, these are tough cases. These are tough cases. And I've handled a lot of tough cases. This is my first rodeo as far as handling tough cases. This one takes the cake. This one was one of the up to date, in my 24 years of doing this as a judge, one of the toughest cases. And you all are amazing. You're amazing people. You are smart, you are attentive, you are patient, and you are just. You are just. And I just want, on behalf of everyone involved, not just the parties, the attorneys, myself, our entire community owes you a debt of gratitude. And I wish I could do something more for you other than just say how amazing you are I did have the bailiff give you all just a small medallion, it's just a token. I wish there was more that I could do, but that is all I can do. You all should go home, and as you resume your lives, be so proud of yourselves for the citizens you are and the sacrifice that you made for all of us in our legal system. We are eternally grateful. With that, your jury service is now concluded. Thank you.
All right. Jury's out there.
Okay, very good. Okay, so we need to set a date for sentencing and all post-trial motions. All right? So, how much time do you all need to get the motions drafted? We're looking sometime in June?
Yes, Judge, I would ask for a couple of weeks.
Okay. So, I know summer can be a little tricky. How are you guys looking the week of June 22nd? I could do the 22nd anytime, the 23rd in the morning.
Judge, the 22nd would work in the afternoon.
Okay. Mr. Gonzalez.
Fine with 22nd, the afternoon, Judge.
Okay. Ms. Finkelstein. That works. Okay. Mr. Sonardi, Ms. Toomey.
Afternoon is fine.
Okay. Mr. Petrinas.
I have a trial that week, but just a 1 day here in Hillsborough, so I can just get it someday that week. Different day.
Sure. And just let me know who the judge is. I'll make a call. Not to worry.
Okay.
Okay, so we're going to set sentencing for June 22nd at 1:30, and all pre-trial post-trial motions need to be filed no later than June 15th. Actually, make that June 12th close of business in the state if you're going to follow the law, you've got 15 days. Okay? All right, very good. And sentencing, if anybody would like to speak, they can. That would be from the victim's family or friends, same with defendants. I mean, the sentence is mandatory, but in cases like this, when it comes to sentencing, I would like to give everyone a chance to say whatever they feel needs to be said, as long as it's respectful. Okay?
Yes, Your Honor.
Okay, very good. See you all then. We are concluded.
All right, so all found life without parole. They were all found, or sentenced, I should say. They were all found guilty, we know that. So they were all sentenced to life without parole.
Not sentenced yet.
Oh, well, not yet. The jury recommends life without parole. So no DP. June 22nd at 1:30, we will find, well, it's pretty much going to be victim impact statements, and the judge isn't going to say, oh, well, I'm going to let you guys go. It's like a formality, but it has to happen, right? It has to happen. So we're going to stick around for maybe a press conference, because I would expect a press conference right now. So we'll stick around for a press conference. So, and it's interesting. I don't know if you guys caught it, but when the judge's assistant, when she was reading it, she was when she was first looking through it, she said they're all the same. I don't know if you guys caught that or not, but she said, she kind of whispered it. She's like, they're all the same, something to that effect. So that's when Isaiah was the first life without parole, and I was like, okay. That it's going to go that way. So thank you, Good Vibes. Appreciate that. Judy, it's capital offense, first degree, and one aggravating factor has to be met. So the jury looked over the aggravating factors, and they decided to go with life without parole. Brett says, technically the judge still has discretion on the sentencing for the lesser charges, but for the top charge, she has choice of one option now. All right. C. Gilmore, you caught that as well? Yeah. I'm pretty sure she's like, they're all the same. That's what I heard. Can the judge change the DP? No. No, she cannot go up. She could go down. She cannot go up. So if they had suggested the DP, she could go down to life without parole. She cannot go up from life without parole up to DP. She cannot. She cannot go up. So she cannot go up. Elspeth, DP, but no life either. 50 years is a death sentence. Yeah, well, every defense attorney said they're going to die in jail. I mean, let's not kid ourselves. They will die in jail. It's just, is it going to be by the hands of the government, or is it going to be by natural causes? I still think, regardless of the outcome, I still think they've. I don't know if this is a legislative thing or what it is, but I wish that they would have these young men. In my mind, they're still young. They're younger than me. They literally could be my sons. I wish that they would have them talk to the communities, talk to these kids that are like 10, 11, 12 years old, and say, don't, and make that part of their quote unquote punishment. Have them go out there and say, we didn't win. We all lost. This destroys families. And if you do this, then you're going to get that. I do wish that I wish that, because we're hearing from Rashad and Sean, they want to be positive beacons still. They want to give back to society, back to their communities. Well, that's one way to do it, is to go talk to the kids, that are 10, 11 years old, that are looking up to you, because, they may be considered heroes in some circles. They took out the ops, they took out the leader, so there may be people out there that are like saying, yeah, way to go, guys. That's I don't know. I think it's got, they're gonna end it here. All right, let me get my where's my thumbnail? They're gonna end it here. I can take my clock off. I just wish that they how do they give back to society? How can they give back to society? Because the jury thought that they still are redeemable, or they still have redeemable factors. So how can they give back to society? Let's see, Stella. Your sons are all about their age too. I have 3 boys, and the little ones have a prom today, and just to see other kids his age are doing life without parole. Yeah. Ionine says, agree, lots of former members go on to do youth mentoring. Yeah, I mean, somehow this cycle has to end. I think we can all agree with that. I don't think anybody wants to go to prison or get shot and killed. I mean, who wants that? Who wants that? Or have their mother's house shot up? I think that was Rashad's house. Or no, it was Queso. I think it was Queso's house. Hakeem Ra. Anyway, it doesn't matter. I mean, well, it does to them, but in the grand scheme of things, people are losing family members and friends, and like what. Let's try and get something positive out of this. All right, let me see if I can find a news conference or something. Let's see if we can find a news conference. If you guys see something, let me know. I'm on a couple local channels. I don't think the big channels are going to have it. I don't think they're going to have anything. I don't even think there was a news conference after the guilt phase. Oh, let me try, let's see, First Coast News. They might have something. Or Orlando, they might have something as well. Let's see here, anything. All right, nothing there. Let me try Orlando. If you guys see anything, let me know. Anything here? Talking about Tampa Bay Rays stadium deal. We don't care about Tampa Rays stadium deal. We want a press conference. We want to hear from Sandrikas. We want to hear from the prosecutors. Ugh. Everybody's talking about this. The baseball team reached a deal on their stadium. I don't care. I want to hear from Sandrikas. I want to hear from the state. I want to hear from the defendants. All right, we'll hang for just a little bit, see if we can get a press conference. And then I think we'll call it a day. I think we're going to take the rest of the day off, work on some videos, upload some videos, some shorts. And then Saturday, please join us Saturday, 7:15. I'm going to be on Florida PI Sam's channel. She's going to be hosting it. I'm going to be hanging out with her. So please join us, Florida PI Sam. If you don't know who Florida PI Sam is, definitely go check her out. I will drop a link right now. I don't have the prompt, but here's Florida PI Sam. Saturday. Oh, there it is. Thank you, Aaron. I got to copy and paste that. All right. So definitely, I'm just going to leave that up. So tomorrow, Florida PI Sam is going to be hosting this. I'm going to be her guest, and we'll be talking about the penalty phase. So please join us. Bring your questions. We have a couple questions already. C. Gilmore, post your message. Which message? All right. So still not, C. Gilmore, I'm not sure what message you're referring to. So I don't see, your radar went up on that. I don't see any other. I'm not sure what you're talking about there. Was photo and video? I'm not sure. I don't see it. Let's see here. It's not looking good for a press conference, but you never know. IMO, in my opinion. At least I hope that's what it means. All right. Doesn't look good for a press conference. So I don't think we're going to get one, or if we get one, it's going to be later. So maybe we could play that. Maybe we'll just play that at another date during their sentencing or something, because I would like to hear from some of the people involved, the defense, the state. Sandricus Mays, maybe she'll release something, but it's not looking good right now. Come over here, yeah, they're down as well. All right. So Florida PI Sam tomorrow, 7:15. Please go check that out. I will be her guest. Looking forward to that. Looking forward to talking to her about that. Please come over and hang out with us. Yes, it's going to be pajama party at Florida PI Sam's. It's going to be pajama party at Florida PI Sam's. Let's go hang out. We're going to hang out at Sam's house. Bring yourself. Let's definitely go hang out. Let's see if we can get the likes up. Ooh, 252 likes. Hey, if you can hear my voice, definitely hit the like. Appreciate that. Let's see if we can, before we sign off, please hit the like button. Let's see. Alexander says, it would be great to have them mentor kids, but until the powers that be start putting jobs and opportunities into the hood, this will keep on happening. Totally agree with that. It invariably boils back down to putting a roof over your head, having food in your belly, feeling safe walking down the street. And a lot of that is economic. And, sorry to say, it's true. It's true. I agree. The pretty chick, you will be there tomorrow. Awesome. Florida PI Sam is eager to see your questions. Linda, sentencing is going to be June 22nd. June 22nd at 1:30. Horse welfare. June 22nd at 1:30. Thank you, JMS. Appreciate you being in our chat. Scott says, thanks for the marathon trial. I respect the chat and the verdict and the host and the moderators. Thank you. Appreciate it. That's all we can ask for. That's all we can ask for. All right, you guys, I think that'll be it. I think we'll call it a day. I'm not seeing any possible press conferences. If there is something, maybe we'll play that on the 22nd. So it seems like that's it. So, all right. So with that, we will say goodbye. Thank you guys for joining us. Life without parole, LWOP. Everybody got LWOP, and sentencing will be June 22nd. So all 4 defendants, life without parole. Sentencing will be June 22nd at 1:30. Appreciate you guys spending your day with us. We are going to be working on some videos now, so we won't come back and stream anything else today. But Monday we are going to have an Ego Takes the Stand. That will be all day. I'm not going to tell you what it is. I know I'm gonna hold off on telling you what it is. And then Tuesday is going to be Paul Canero, his sentencing. And then Sean Higgins, we're going to, I'm not sure, I don't think Paul Canero is going to go all day. So we'll cover some Sean Higgins. So we're going to stay in New Jersey, the great state of New Jersey. And then Wednesday, we're going to start our deep dive into Carlos Dominguez. His trial starts the following Tuesday. So lots of really good stuff to look forward to. And then August, we've got Shanna Gardner, we got Tupac's, we've got Courtney Clenny. We've got a lot of things happening in August. So a lot of good things coming up in the upcoming weeks and months. So appreciate you guys being with us. Thank you for supporting our channel by just hanging out with us. And, for those that are able to, giving super chats and memberships, definitely appreciate you guys. Thank you so much for that. And Dwayne, as always, I shall leave you with Super Ball. Your girl's Super Ball. She's got a full belly. She's right over there. And got little Bean over here. Yes, a good girl. Yeah, oh, choco girl. Got a little bean there. I've got some pizza waiting for me, so I'm going to go enjoy some pizza and a salad. All right, guys, thanks again for joining us. Really appreciate you being with us. Thank you to our mods for keeping our space respectful and courteous. And thank you to Erin for all that she does on the back end. Have a great weekend. It is Friday. Enjoy your weekend. Make sure you do something positive for yourself. You can't change the world necessarily, but at least you can change the your situation if you can for the positive. Even if it's just a smile. You never know what somebody's going through, you never know what somebody else is going through. So a smile goes a long way. And respect and courtesy goes a long way as well. So for those that are able to, please do so. And we will see you guys on Saturday, 7:15. We're going over to Florida PI Sam's house, and we will see you there. Okay, take care, guys. Bye.
Thank you.